deliberate definition of IP and what IP is came from the World Intellectual Property Office definition. And there's 2 slides. And the purple is my writing, is my highlight. So intellectual property refers to creations of the mind. Okay, creations of the mind, it's what you do, such as inventions, literary and artistic works, designs and symbols, names and images used in commerce. Okay, the use in commerce actually is quite an interesting point, and we'll come back to that in a minute. It goes on to say, IP is protected in law by, for example, copyright, trademarks, and patents, which enable people to earn recognition or financial benefit from what they invent or create. Do you see that, everybody? The IP laws are to enable you to earn recognition and financial benefit from what's coming out of your minds. It doesn't say anything there about lawyers. It says that the IP laws are there for your benefit. So please, when we go through everything, remember that. It goes on that by striking the right balance between the interests of innovators and the wider public interest, the IP system aims to foster an environment in which creativity and innovation can flourish. The IP laws are there so that you flourish. Has anybody ever mentioned that to you before? Did anybody here realise that that's what IP was about? Okay, it sort of goes, oh, okay, this is great. It's for me. It's not for anybody else. It's for me to allow my creativity to flourish, and for me to be able to earn a decent revenue out of what I do. Okay, so please, please hold that thought as the underpinning of everything that you do creatively. It's there, those laws are there to make you, your life, your creativity flourish. Okay, so intellectual property, which we're going to look at first today, is split into 4 areas: copyright, trademarks, design rights, and patents. Okay, and we'll touch on each of them. But we're going to start with the most important one is copyright, okay? And it's fundamental to every single person in this room's business. We'll come to trademarks, design rights, and patents in a minute, but you have to pay for those. Copyright is a free right. Anything that you create, you turn from here into something, and it has to be turned into something, belongs to you, unless you're doing it, on somebody else's payroll, and we can talk about all of that later. But if you create something, you own it, okay? That's it, job done. It's an automatic right, so you don't have to register it with anybody. And it's a property right, okay? So you can do, just as if you have a piece of property, you have a house, you have a car, you can choose whether you want to sell it. You can also license it, okay? You can do all sorts of things with it because you own it, it's your property, okay? And it protects copyright, as it says here, it doesn't protect the idea, it's only the output of it. So you can't just go, oh, I've had this idea, and just talk about it and it's protected. You have to turn it into something. Now, you may turn it into a script, you may turn it into a proposal, you may turn it into a slideshow, you may turn it into something. As soon as you've a sculpture, as soon as you've turned it into something, that's your copyright, but it can't be an idea. And it protects what you produce, across any particular form of creativity. It's automatic, right, free, can be invisible, and don't need to register. Oops, sorry, I enlarged the size of that and drop the R off, and it's a property right, okay? So any quick questions about copyright while we're just still here? Yeah?
Will we go, because the first one clearly shows how AI, which is now like a big concern, is affecting the copyright property of many artists, the way something like Midjourney was trained.
Okay, so
and the lawsuits are
AI...
coming.
AI is a really interesting concept. This week, because I have to read legal IP newsletters, who has more fun than me reading that? Okay, AI is a really interesting situation because some countries are saying that a person has to register or has to be the owner of copyright, and some say that the coders are going to be, and that AI can be owned by an organisation. So the jury is out legally on that at the moment. Different countries are oh, hello, we've got some.
All right, I'm another speaker in this program. I happen to be an attorney. I taught IP law. I'm an IP attorney. I'm going to directly address AI-generated art in my talk. Two other quick comments. She's quite right, copyright in the EU in Cyprus happens. Like that, you created it, you got it. There are jurisdictions where that is not the case, so if you are playing in global marketplaces, be aware that what applies in Cyprus and in the EU may not apply someplace else. You need to check whether you have to register or not. Everything in intellectual property is country by country. Although you can get when she talks about patent, there's a European wide patent now. The other thing, real quick, is the original form of intellectual property, which we'll talk about later, that you have to remember, is trade secret. All intellectual, you've got something on trades, all intellectual property is actually derived from trade secret.
That's lovely, and it's fantastic to have you here. Thank you so much. Okay, so let's be clear. You own the copyright of everything you create, but it has to be something real, not an idea. You can show you own the copyright by using an internationally recognized symbol, which is that, okay? So when you're presenting, if you're presenting to a client or something like that, and you have not, through the contract, had to pass over your copyright, or your intellectual property, which you sometimes have to do in contracts, really, really make sure that you cover yourself by stating that you own the copyright and that you put a copyright symbol on everything. Right, and copyright covers all sorts of different things. So, for example, it can cover the code, but it can also cover the interface. So this was an app that I worked on at various points. The coding was protected by copyright, and so too was the interface. Illustrations. Illustrators own the copyright of what they do, and you also own the script if you wrote that copyright of a book. This is a new VR game, and what's fascinating about this particular game, any VR game, is there are primary rights, which is the game as the whole, okay? But there are also secondary rights, which could be you also own the copyright of the bits within the game, okay? And that can generate secondary revenues. Primary rights are the whole thing, and secondary rights can generate revenues in all sorts of different ways. So, for example, if you come up with a TV format that you have in one country and you want to sell it in another country, you could, for example, sell the music as a separate part of that format in a different country, okay, and earn revenues out of that. Okay, this is a company that organises events. They own the format of the event in the countries that they do it. So this particular company owned all sorts of different event type shows and things like that. And once they realised they could own the copyright of that rather than selling them to the leisure centre, the leisure park where they were hosting them, they realised they could sell their format around the world in different ways. And they also launched a children's training program, online training program, that could be downloaded in all sorts of different ways, because they made sure they kept the videos, the ownership of the videos and the films of all these training things. So lots of different ways. I wrote a book. I own the rights under the copyrights law to publish and distribute it. I can choose who can copy it. I own any media rights around it. I have the moral rights to be named as the author. I can license usage of it, and those rights can either be owned by a person, by me personally, or I can choose that those rights be situated in a company. Yes?
I would like to ask, in the case of something that is collaborative, for example, a film or a video game, where there is a team behind it.
When there is a team behind it, yeah.
Exactly. Like, for example, the video game that you showed earlier, perhaps has music from a musician.
Yeah.
But it also has design from a 3D animator.
Yes.
So the copyright for these both creative materials which are combined, are they individually controlled, or is it like under the team directly?
It depends what you have decided to put into the contract, okay? Which I realise sounds a bit of a get out of jail free card, but for Pirate Queen, that has been funded partly by Meta and various other funders. So they have funded the company, and so Eloise Singer, who runs the company, has stipulated that in all contracts there is a buyout, and they will get no, they're not going to take part in any revenue waterfall system out of any of that. Okay, so you have to, as the owner of a company or as a supplier to a company, you have to make sure that the intellectual property position is very, very clear to you. Now, you could license it. You don't have to necessarily completely hand it over. You could license it for a given period or whatever. There are various mechanisms for it. But you have to decide those before you go into it, okay? Whether you're a company owner or a supplier, okay? Or whether you're working in a team, okay?
Sorry. Also, I guess that's how voice actors and other kind of artists get deals for royalties of these kind of things, like animated shows and video games.
So there is a royalty, or you can sign away all your rights for your contribution. I mean, there are all sorts of different mechanisms. So what I'm trying to do here is the sort of basics rather than to go through all the different details. Okay, so as I've said, the copyright is the whole work, and it also can be the constituent parts too. So, and this isn't a very good. So if you think about the Pirate Queen is about a VR game about a Chinese pirate woman who controlled the biggest pirate fleet, a 70,000 strong pirate fleet in China at the end of the 19th, early part of the 20th century, I think that's right. So all the constituent parts of this game are owned by Singer Studios, who created it. It's not just the whole, it's the bits. Okay, now let's look at trademarks, okay? Now, unlike copyright, trademark is not a free right. You have to register a trademark, and the registration is different in most countries. So really, really check, and we've got somebody coming, we not only have Phyllis, but we've got an IP lawyer coming today to talk about the position in Cyprus. Okay, so what trademarks are there to do is to differentiate one company and its products from another, protecting from passing off. They can be words, graphic symbols, or both together. They can be 2 or 3 dimensional. In the UK, it has to be registered by the UK Intellectual Property Office. The registration lasts for 10 years and can be extended indefinitely, provided you use it. When you register or want to register a trademark, you only need to register a trademark if there's a commercial reason for you to do it, okay? There's no point in spending money registering something if you're not going to then trade under that trademark. And when you do register, you need to decide which of 45 classes you register it in, okay? You can register it in one class, or you can register it in several classes. And classes 1 to 34 relate to goods, and classes 35 to 45 are services. And those classes are globally recognised, okay? Now, you can choose to recognise you can choose to register a trademark in one country, your own, or you can register it in a selection of different countries, and you just pay for the countries you register it in. You are familiar with trademarks, and these trademarks, the blips on your phone, the buttons on your phone, are pretty much registered trademarks. You use them every day. And a trademark owner can choose whether to license it, whether to sell it, to link it to a company name. It could be linked to a product, or it can be linked to a service. Okay, it doesn't just have to be a company name. But the key point there is it going to be, if you register a trademark, is it going to provide commercial benefit? So here, Cadbury Dairy Milk, everybody's familiar with this. This is a registered trademark. But also, the colour is registered, and some of these elements can also be registered under design rights, which we'll come to shortly. This is an interesting story, which was a design company that I worked with in London. We identified that their clients, the clients that brought them business, when we sort of began to pull apart all the different clients that they had, which were in a really wide spectrum, what we identified was that the clients, customers, all came from a really, really narrow section of society, but actually which helped brands to grow. So what we did was, I said, why don't we give that particular section of society, which hadn't sort of been identified very clearly, why don't we give it a name and trademark it? So without the studio, we came up with the idea of calling them urban adventurers. We trademarked the term urban adventurers, and then they produced this wonderful, wonderful book, which was effectively a sort of a big marketing Bible about urban adventurers, about this part of the community that they had been working towards. They registered it, I think it was in 12 or 15 classes, and there's some really interesting stuff. Various people have approached them to license the term urban adventurers from them for different things, but also, this knowledge of this particular sector of the market, they use this as a really fantastic marketing document. There's stories about what sort of lifestyle urban adventurers have, who they are, what it's like designing for them, what products they might like in the future. So, you don't just have to use a trademark for a name, you can use it for something that, that has purpose for your business.
Sorry.
Yes.
Can I ask, so with the trademark, how does it work in terms of, because obviously I'm assuming if someone's just writing a book, they can write urban adventurers without having to put TM in the middle of a...
Yes, because they would be covered by copyright law.
Okay, but at what point do you have to lease the term?
What point do you have to trademark it?
No, if you have trademarked it,
yeah.
When do I have to, I'm assuming, pay you if I'm using it?
They were approached by a brand who wanted to use the term urban adventurer for something, and that brand realised that they couldn't use the term in the UK because it was in the class. What they wanted to do, what the brand wanted to do, was covered by a class that Without had registered urban adventurers in, okay, and it would have directly infringed that trademark. So they contacted Without and said, we want to launch a product that is this, but you have the trademark in this area. So they came to a deal as to how it could be used by that client, and that client paid the license.
Yeah, I guess I'm wondering more like, when does it take effect and when does, because obviously me as a private person, if I say urban adventurers, I don't have to pay it.
No.
But if I put it on where's the line? Do you know what I mean?
When you're trading with it.
Oh, okay.
Think of it this way. You sit in this room, say urban adventurers. Are you selling anything?
No.
With trademark, if I sue you, I give you damages because you're making money off it. You're not making money off it, nothing's happening. Now you go out and you say, look at it, it's on my cup. I'm suing you. It gets worse than that. You hold yourself out as engaging in something where you're going to make money off of it. I'm suing you. Because now you are, as she rightly pointed out, in commerce. From the standpoint of the trademark owner, you cannot just license the trademark. So you have a mark that you want to license. You also have to enforce the trademark. You have to go out and see who's out there using it. That's why Coke is very active in these kind of areas, or Apple, with the I whatever. They go after everybody. So you have to enforce it.
Yeah, they went after Samsung with the square and the circle.
Right, yes. And so enforcement is one thing. And if you do license it from a company where they are an established firm, there are going to be lots of proactive things you have to do because they do not want the brand being cheapened. So if you put it on your cup, you're just a pot of making cups, we want to say urban adventure on it. They're going to make sure that your cup doesn't break when it falls or whatever they think is important. And you're going to have to adhere to whatever they want you to do. It's not an uncomplicated thing. So the bottom line is this: if you're going to play in this game at that level with a big company, get a lawyer. Anything we teach you in here today will not be useful. You need a lawyer.
Yeah.
Can I ask something? Can I ask something on that thing?
Yeah.
What if it's a different medium? Like if it's not a cup, it's not a t-shirt,
Doesn't matter.
but it's
Doesn't matter.
no. If it's like an NGO teenagers event that I call
Are
urban
you
adventure,
using the?
and I don't get any
Are
money.
you using? It doesn't matter. They can still go after you, shut down the event.
That's what I'm asking. So it's not only if they're actually, if you actually.
No, you're
trade
out
them.
there in public in commerce.
So it's not only trading. It's
No,
about
it's
being
being
out
in
there.
commerce. Or being out in public doing something. But the point is this: if, let's say, you're using, I'm going to use do they do Caterpillar? Anybody know what Caterpillar is? They make big construction equipment. You would think Caterpillar would only apply to, as a trademark for construction equipment, but they also sell clothing. They license it for all other fields, for a bunch of different fields. So it all depends on how that trademark is registered and what it is registered for, what it applies to.
And
And a big company, you're screwed. A small thing, you're probably not screwed because it's probably not known for something.
And you can check, you can go online to your local registration. I do a huge amount of searches in the Intellectual Property Office in the UK, and it's got both world, European, and UK registrations on it, and I'm sure it's exactly the same with your registration system here. And I was about to say, but it will be confirmed by.
The other thing to be aware of is, just because it's registered in the United States, Britain, France, Germany, doesn't mean it's registered in Cyprus, and you may be free to use it if it's not registered.
But that would mean that you could trade with it in Cyprus, but you couldn't trade with it in the UK,
Germany, France, wherever
and
else
the
it
US.
is registered.
Okay, so it's really.
Once again, you're going to use somebody else's trademark, get a lawyer, it's worth it.
Think of your own.
I think it was kind of answered, but so when you register in one class specifically,
Yes.
if you want to cover different things like a book term or a service, so you would have to pay for each different class, or you just take kind of.
No, you have to, when you register in the UK, and it will be probably different for every single country. In the UK, the main registration fee covers one class, so that's about between 150 and 200 pounds, and then there's a further 50 pounds for every subsequent class that you register at the same time. If you suddenly realised you'd left off 3 classes, you'd have to go back and pay that registration fee and re-register those classes. Okay, plus and add those extra
And
ones.
does that cover you only for those classes? So for example, if you use a term for a book, but I want to use it for something else, that's not in that class, would that be a possibility?
So for example, a book is covered in class 16, which is paper products. So if you wanted to use that term for a magazine as well as a book and that sort of thing, that would be covered in that. But if you suddenly wanted to use it for, let's say, an advertising service, then that would be a different class, so you'd have to register that as well.
So I would be allowed and I would be able to register.
Provided somebody else didn't have the registration already of that term in that class, okay?
One other thing to be aware of. Just because you get a registration doesn't mean your trademark is bad. Even in that jurisdiction. Because all that has to happen is somebody can go in, depending upon the law in the jurisdiction. Under English common law, this is the case, which tends to apply here in Cyprus. If you go in, you register the term Schlickelgruber. You're like, nobody's using Schlickelgruber. Great, I got Schlickelgruber cups. I find out about it. I'm an old fart. I've been making Schlickelgruber cups since since 1957, right? And I go and I say, you can't have that trademark because it's already used in trade. I never registered it. Doesn't matter, but it's used in trade. It is not unique to you. You lose your trademark. So just because you did a search and didn't find anybody else making cups, you better be damn sure that your search is comprehensive, or you could get a very nasty surprise down the street.
So
You
that's,
can't be sued because you're not infringing their trademark, but you could be made, your trademark will disappear.
that's unregistered, okay, unregistered trademarks, and there's also the equivalent of unregistered design rights. So the onus is on you to do really, really thorough searching. Oh, sorry, so design rights. We're talking about design rights now. Okay, so a design right protects the shape and appearance, okay? It can be 2D or 3D, and an unregistered design right, which is what we've just been talking about, an unregistered trademark, can protect for 10 years after the first sale, okay? Registered design rights, however, can protect for 25 years, and it needs renewing every 5 years. So a registered design right in the UK, you have to send the photographs of all angles for that particular product, or drawings in. The design, in order to be able to register a design right, it has to be new and have its own characteristics. And again, in the UK, we register it via the Intellectual Property Office. There is also an organisation in the UK called ACID, which stands for Anti-Copying in Design, and it would be really worthwhile to find out whether there's, I know that only works in the UK, to find out whether there's something similar. We're getting a negative shake of the head here. So there isn't, but if you're doing anything in the UK or selling things in the UK, it could be worthwhile registering with ACID. And what ACID does is a registration service, and they will help you defend anyone that it looks like they're infringing your design right.
In Cyprus, this will be called an industrial design.
Okay, thank you. Oh, it's lovely having you here. Thank you so much.
Can I
Yes.
ask you, you mentioned trade before, and here you said after the first sale. What if there was no sale?
So, hang on, let me just go
Because
back.
there's so much things that are not being sold.
Yes. So,
Do you have the rights?
there is, you have a copyright to something, but to have a design right, you can register it, but you can also have an unregistered design right. But you can't, somebody doesn't know what's in your cupboard at home, so you can't suddenly say, if you see something on the market, that, oh, that infringes my unregistered design right, because it wasn't for
an
selling.
exhibition, or if it was like If it was a prototype that was shown, but was never sold.
There has to be a commercial, you would have to be able to prove that, and we've got
Even if you show
legal guidance over here.
I'm sorry, I missed the question, I was just stretching.
Okay, so the situation is a prototype or something in an exhibition which has not been traded and somebody else picks it up. Would that be covered under an unregistered design right?
Possibly. So think of it this way, there's two bodies of law in companies that use British law, or countries rather, that use British law. The United States, Canada, Australia, New Zealand, Cyprus, former colonies, right? Brits brought their legal system with them. There's what's called common law, which is the law of judges. Not written down anywhere, relies upon precedent. Study decisis, for those of you that speak Latin. And then there's code, which is legislative law. The EU only has code because it's a civil law system. Civil law means it's a code system. Comes from France. Because we have common law in Cyprus and other former British colonies typically, there are unregistered copyrights, unregistered trademarks, unregistered design. Here you have, I guess in Britain, you have unregistered design rights. You don't have that in the US. I'm not sure if you have that in Cyprus or not. I just never had it come up as a question to look into it. But where you have a common law protection, the rule of thumb is you can use it to set something aside. It is harder to sue on it because it's very hard to prove that anybody was aware of it so that they are infringing knowingly. And if they're not infringing knowingly, you're going to go before a jury. And what's the jury going to say? You didn't do anything else. This poor schwab who, was making their pot knew that that was your copyright. They didn't mean to hurt you. So stop using it. And that's about usually what you get. So if you're concerned about protecting a right, register it. Now, if there's no registration, in Cyprus, in the EU, you don't have to register. It's automatic. Then you can sue on it, but as was rightfully pointed out, it's always good to put that little C there to put them on notice that you will sue. But it's not a mandate of the law, it just makes it easier to prove the case.
Okay. Right, so here's somebody that you will recognize, okay, protected by design rights, okay? So, and if you're going to put something in for design right, make sure, so here are transformers, make sure that you do both all the different stages if something can be transformed and that it is shown from different angles. Yes?
I wanted to ask, because for me, okay, I understand the purpose of protecting something, but how well am I protected under these schemes, for example? The Lara code you showed there, let's say I made some changes on it, I want to produce something similar to it, I want to take advantage of the commerciality of that image, but I don't want to get sued and I don't want to create a new one, so I will change it a little bit on the image. Am I covered? I mean,
okay, that's a very, very fine line because...
Actually, it's the line that I want to understand.
I'm going to address fair use.
Sorry?
I will address fair use.
Okay, so you'll address that later. Yeah, okay, we'll cover that. Okay, so this interface, thank you. This interface, okay, this is also protected by a registered design right, okay? Right, now we're going to look quickly at patents. Somebody has already spoken to me about patents this morning, and normally I don't get too involved in patents because many of my clients don't have them, but we have got an example here. Okay, a patent protects the concept behind an idea, okay? So it's a process, a formula, program, system, or some other concept. It has to be new, and it has to be undisclosed to the public and to even your wider circle of friends and contacts before filing, okay? It has to involve an inventive step, and we'll see in a minute an example of an inventive step. It has to be capable of being made and used in some form of industry, and it's absolutely best to work with a patent attorney. You need really, really experienced people across this. And just to be aware, patent registration is lengthy and can be expensive depending on where you're registering a patent. Okay, this is an example of a tiny company that discovered they got a patent. I went to a club opening a few years ago, and there was a great young woman there called Mel. And we started chatting, and I said, what do you do? And she said, oh, we run events. We run events in sort of dating events in pubs, board game. We get everybody together for board games in pubs because we're fed up of online dating. And then she held out a tray of what looked like sweets to me. And I said, oh, what are these? And she said, to break the ice, we have these sort of large gummies that have got that are sort of have got alcohol in them. And she said, just to warn you, you shouldn't eat more than 3 and then drive. So I went, so you've retained the alcohol in this sweet? I said, what, like, sort of cherry liqueur sweets that you eat at Christmas? And she went, no, those don't have any active alcohol in them. And I went, so how have you managed to keep the alcohol active in something that effectively has been cooked? And she went, well, it's a system that my boyfriend's developed. Anyway, I said, this is really interesting, and I think that there's more opportunity in this business than in running events in pubs and playing games. So we went and had a sit down sort of the next day in a meeting, and she didn't tell me anything about the process, but I tried a range of these. There was gin and tonic, there was vermouth, there was whiskey sours, there were all sorts of things. And I said, I think that you could have a patent here, but I'm not sure. So I'm going to introduce you to a patent attorney that I know. What was really interesting then was the patent attorney unpacked what the inventive step was in their process. And what was fascinating was that he identified that the inventive step was situated in the fact that the alcohol combined in an interesting way with the gelatin that made the sweet. It wasn't the sugar syrup or the alcohol syrup that was heated, it was a gelatin-based alcohol. The alcohol sat in the gelatin. And what he identified, therefore, was a potential patent for all alcohol to be retained in all foodstuffs that had gelatin within them. Now that widened the opportunity for a patent much more than having the alcohol sitting in a sugar syrup. And what they effectively did was locked Diageo out of anything because they applied for a patent. Diageo then could not look at keep retaining the alcoholic properties of alcohol in any form of gelatin-based foodstuffs. So this tiny business of 3 people ended up running the innovation kitchen and working with the innovation kitchen at Diageo and Pernod Ricard. And this particular company was then bought for $6.5 million. And that was before Mel was 30.
So is the patent primarily protecting the inventive steps, not the...
No.
No.
What a patent protects is a claim. A claim is like how you do something. Don't think of it as the inventive step or you'll get confused. I mean, it is what's unique about it and inventive, and it has to be reduced in practice. The patents are about how things happen.
Technology.
What?
Technology.
Technique, not technology. Technique. You know what the first patent in history was? It's a great way to understand a patent. It was in ancient Greece, in Syracuse. It was for a recipe. Literally for a recipe. Somebody in Syracuse had a recipe that they used in something that probably some kind of soup or something. That's the milk-based soup here.
Okay, so we have to.
They used to call it Trovanis Americanus. But yes, so it protects the recipe. Each claim is all that's protected. So if you think about it as an inventive step, you get a little confused. I'm not saying that's wrong, but it has to be more precise. It's a way you do something that is not in nature, that's not in logic, that's not in math, it's human created. And it is a technique, not technology, although technologies typically are patented, but a technique, which means a technique.
Let's try to keep all the questions for the end.
We're going to have to
of the session, please.
Okay,
because there are
don't worry. I mean, it's great. We can just use up the time that we've left. So this is a client of mine at the moment who are interactive storytelling mechanism. They are very new and they have literally just registered for a patent because they devised a game building, choice-based game building mechanism that means that you don't necessarily have to build a game in something like Unreal. Okay, so as I mentioned earlier, trademarks, design right and patent you have to register. Okay, things on the left, copyright, presentations, pitches, proposals, films, games, apps, all those things that you create, you own the copyright for those, you don't need to register them, but though in the US, copyright does have to be registered. And then there are...
Cypriot does not have to register,
No,
it's just
that's
Americans have to register.
Yeah, I just said, sorry, in the US.
In the US, you don't have to register it, it's automatic. If you have it here, you have it there.
Then there are trade secrets.
I have a question though, for the rest, except for copyright, you have to register it here in Cyprus as well, or no?
I'm a little unclear where, I believe you do. There may be common law copyright in common law other than trademark, but I'm not positive, I don't know.
Okay, so then there are trade secrets, okay, which Phyllis referred to. So trade secrets are things that happen in your business that you might make within your business that you do not want to escape beyond your business, okay? So you might limit who knows about them. So for example, Coca-Cola's recipe is the classic example of that. There are very few people that you want, that know the Coca-Cola recipe. So trade secrets are something that, you want to keep within. You might, those people who know, you may give them that they're not part of their contract is they're not allowed to disclose it in anything else. So these are things that you also need to make sure within your business are protected. So how can you use your IP and assets inventively, unexpectedly, with originality? How can it all work for you? Okay, so let's look at some instances of copyright. You own the copyright to all these different things that you have, okay? If you're presenting at meetings, your social media, if you need to make sure that you're not infringing other people's copyrights on your social media, but social media is there to be shared. So, you just need to be aware. You can put all sorts of different things about copyright in your contracts too. So, for example, ad agencies will often have staff that when they're presenting to clients, they yap away and give lots of ideas away. And I worked with one of the M&C Saatchi's companies, and what I suggested that they put in their contract was a clause that said that they would not, if they saw some commercial opportunity with the client's business that was outside of their brief, that they would present it to the client in order that they owned the copyright for it and they owned that idea rather than just freely blabbing away ideas. And when the legal team at the top of M&C Saatchi had to approve this particular change to the contract, they just went, wow, if we'd done this years and years ago, we would have made a lot more money. So, really make sure that your copyright is on all these different things. Now, we talked a bit about a license. Everybody's familiar. Pantone has has registered several trademarks over the years. It's really fascinating looking at their trademark registration history. And they only started registering their an opportunity to license all sorts of different things in the sort of home furnishing markets and things like that in about the early 2000s. They suddenly saw people had moved from printing to digital, so they realized they were losing money, so how could they make money out of what they did? You can also, if you come up with a format, this is a VR program called Telltale Rooms that one of my clients make. She's an amazing artist, and they did a VR experience of what the rooms in her head look like. Phenomenal film. And I sat down and went, you've got a format here, because you could do the same thing with any artist, but you could do a whole series of artistic films, so you've got a format that you could potentially license. This was a whole series of adventure RR games, that there were 23 books in the series, written by Joe Deaver in the 70s. We took all of that copyright, okay, and have turned it into online games. They've bought all the myriad licenses that were around the world back in. They're renegotiating them, so again, they can make more money. You know, remember when you're using social media, make very sure that you're not infringing other people's copyright, okay? You have to be very careful of that. When you're thinking about the digital space, you can also own the copyright of what you're developing in that digital space. Okay, so you really, really have all sorts of copyright available to you. And then we have somebody here, I can't remember who it was, that's Serdik, who's working with NFTs, okay? If you're working with NFTs and things on the blockchain, the contract, the original contract that is generated for the NFT will determine, because you cannot change a blockchain contract, will determine who has rights with that digital asset during the whole life of it, during the whole ownership chain of it. Okay, so you have to make sure that underlying contract, when you devise, or when your lawyer devises that underlying contract, covers things like copyright, whether people are allowed to do things with it or not, because it cannot be changed. Okay, so if you're going down the NFT routes, you really, really need to be very careful as to who can do what. Trademarks. Okay, here's another example of a creative company who has trademarked their own product, okay? Peanut and Crumb, branded content video company. They realised that during the lockdown in the UK, huge amount of popularity of garden birds and things like that. They came up with the idea for a podcast called Get Birding with a really popular 18-year-old. She's got a PhD at 18. Ornithologist that is very well known in the UK, called Bird Girl. Within the first series, they created their own series, podcast series. Within the first series, it was in the top 5 of Apple's podcasts. However, they realised that Get Birding had real potential in all sorts of other ways. They registered the trademark, and they're really building and extending the brand. So they're turning it into a game. They're building an app as well at the moment. Okay, so a design right. Mars has both the font, the packaging colour, both registered under design right. So, you know, really think through different aspects of your design right. Patent. Okay, now this is an interesting story, and it was one that I was told by the Intellectual Property Office in the UK. But I've since done some research, and I'm not sure about it all being quite what the IPO told me, but there we go. But this, I think, is a really interesting example. This is a blue squash ball. Most squash balls are green or black. Some university students in Canada read a tiny little piece of information in a science magazine that said that the colour that you see furthest out in your peripheral vision is a certain blue. They didn't work in anything to do with vision or anything to do with squash or squash balls, but what they identified was if that was the place that you were seeing your peripheral vision farthest out in, the application, the commercial application that that would have could be for squash. Okay, because when you're playing really high level squash, your peripheral vision, your way back peripheral vision is very, very important. So they went, oh, well, what would happen if we created squash balls? Would it change, you know, how high level players, how fast they could react? So they tried to register a patent for it. And some things I've done have said that they were successful, and other things I've read have said that they were unsuccessful. But what they did, what it shows you, is you don't necessarily need to own all the discovery. If that is out there and you suddenly go, oh, this discovery has an application, could we turn it into something and do something new with it? There can sometimes be a patent available that you could register for that. Okay, so I think everybody, oh, and remarkably, I think we're on time. So it's quite warm in here, so I suggest that if anybody hasn't got any more questions, everybody goes out and gets a bit of intellectual property office definition that we looked at the beginning. I get some of my clients to put it at the very top of their contracts with their clients. It doesn't add any greater protection, but what it does is it says, we are aware that we, as the creators, have the right. Now, one of the other things that I think is fundamentally important when you are developing contracts with clients is that you put the brief that has been finalized by you as part of the contract. So, a client gives you a brief. Who here who does commercial work rewrites the brief? Great. Okay. The reason that it can be really important to look at that brief in real depth and rewrite it is it will show you the holes. It could also make the client read it a lot better and a lot differently because it's said in your words and things like that. When that brief is agreed and signed off by you both, put that as part of your contract. The reason is that I've had a design company who saw that the redesign of a company that you would all know, the brand, they were asked to redesign the brand identity for Europe, for the UK and Europe. The next thing that they find is their work is being used in the US. And they went back to the client and said, had we been asked to include the US and Canada in the design work, it would have cost a lot more because the usage was much wider. It would have had some different, we would have approached the project differently, and we have effectively lost out commercially because you're now extending our work, you know, out there. They had not signed over all the IP rights for the US. So they successfully, they didn't sue, but they were successfully paid loss of earnings because that contract clause was very clear as part of that project brief. Okay?
Okay. Can I ask a second one?
Of course.
I mean, I don't know how true this is legally, but with film scripts,
Yep.
we've been told a long time ago the best thing to do is register, mail it to yourself, send your film script, your film script, register, mail it back to yourself with a stamp from the post office, keep the envelope unopened in order to prove the date of creation of that script.
That's a common practice.
Is that legally valid though?
Practice,
is that
but
Very good. I wouldn't do that.
You wouldn't do that.
Not useless is my reaction. If you really want to show that you own it, register it with as a copyright in the Cypriot Intellectual Property Office.
I mean, the way that various people have said that over the years is they send it to their lawyer to look after rather than registering it to themselves. But
okay, sending it to your lawyer, is that then covered, or is it still better to go and register it?
It's better to register, you know, to register it. Okay? Yeah? Oh, lots.
I just have a question. I'm not an expert, but for example, in the design rights part, as Andrea said earlier, there is a very thin line. And for example, I have a company, I'm designing furniture, and it's quite easy for someone to steal the design. Because today, with all the technology we have, you can scan something as easy as, and then replicate it in many ways. Is it actually better to, I mean, if you put it in like in priority, it's better to register the patterns or the trade secrets than the design at the end of the day in terms of strategy? Because nowadays it's very easy to just replicate something.
Trade secret's a little different. Trade secret is how you're doing something typically.
Okay.
If you're selling a product and everybody can see what it looks like, it's not trade secret because it's already out there.
No, I'm talking about the process.
Well, the process, yeah, you keep as a trade secret.
Yeah, but
Okay,
I'm not sure such a thin line in the design.
It is. Okay, so I
don't know if it's worth like all the pain of actually registering a design.
No, it's only if it's going to be commercially valuable. But I work with Vitsu, you know, are people familiar with Vitsu? So Vitsu is the shelving that Dieter Rams, the Braun designer, Vitsu is the company that Dieter Rams designed the shelving for in the 1950s because he wanted all his Braun products to look amazing on shelves. VITSOE. And over the years, Vitsu in the UK worked with Dieter Rams to get the license for the global licenses back from all territories for Dieter Rams's shelving. And they've done small upgrades, but basically the shelves that you bought in the 50s still work with the shelves you buy today, so you can add bits to them. And they have been copied, and they're currently, being copied in China. But because Vitsu has been in this market and so defined and has changed it so little, they've been able to mount a defense of prior art, so that they have been trading in the market doing this, and that the systems that have been copied in China and have been copied in South Africa and have been copied in Italy, that actually they are copies because they have won case after case after case, but they've had to really, really proactively go after those people to defend that particular.
But they're very clear,
they've got a very clear design.
I think the technique comes in place when
So
we're talking about
let me just answer what you said.
Yeah, because there is a technique, I think, in this sense, what you are talking about. I feel that there is a technique there, so it's very easy to distinguish the difference. That's a very clear kind of.
Right. Yeah. I'm going to show you an example when I talk of a thing called a spork. Do people know what sporks are? Spoon forks? I'll show you just a quick example of how many, you Google spork and you get about 50,000 different imageries of the spork. Do you really want to get the design right on spork? I don't think so. Probably not worth it. You can look at the number of design patents, we call them design patents in the US, on sporks. It's pretty funny. The trick on this kind of stuff is, if it is a process that you're doing and it can be hidden and nobody can see it, protect it with trade secret. Because if it can be hidden and nobody can see it, if you patent it, they can copy it and you won't know that they're using it unless, as in the example here, there's something in the connector that you can say, that's my connector. So if there's not something clearly distinguishing, it doesn't work. A. B, think about what you're trying to protect it for. If you're trying to protect it in Cyprus, the EU, whatever, that's one thing. If you're trying to protect it in China, forget it. Because they don't enforce IP law in China. It's a $200 fine.
There's a very nice local example of this I can actually say when it comes to design. It's called Engino. It's a factory in Cyprus. They created their own Lego systems. And one of the big problems they had, they used to make the fabrication in China. And the molds they used, they were copied under a Chinese company and they couldn't control it.
Yep.
And what they did is that they actually brought the molds and all their innovation back to Cyprus. They're fabricating them locally just to protect the I mean,
well, that will do, but somebody in China will see it. I mean, I launched my own range of home furnishing and garden accessories.
Okay.
And what's really interesting is that there are certain things you design, and when you see Marks and Spencer's then did something, and I knew they'd copied my design because there's something intuitive in you because you just know that they've copied it. And then I discovered that one of the buyers was one of my customers. Who's the lady who, Martha Stewart over in America. Yeah. So I used to send a caseload of products from each season, used to get shipped out to somebody called Lawrence, someone in America. They bought one of all the new things. It was so exciting. I got this great thing. Funny how it turned up in Martha Stewart's catalogue of products. But you just sort of go, okay, I'm always what I think you also have to think about is the world I work in. You have to just always creatively be one step ahead of where they are and just keep doing what you're doing.
And in terms of technique, as far as I understand.
Sorry?
And in terms of technique, as far as I understand.
Yeah.
And originality. Question is there authorship? Looks original, or is it not really original? We don't really know because we don't know if somebody else generated the same image with their question. So it gets a little murkier, doesn't it? Whoops, what am I doing wrong here? Come on, there we are. So now, here's a history. Does this change our answer? This is literally how I got here. I kept on changing the question because I was making this, I do a blog in LinkedIn. And I was doing one on when there's really an inventor, who's a author or an inventor, who's contributing to IP. And I wanted to have a picture of a grizzly bear looking down on the square at the ground of some fruit. The forbidden fruit. And so I was trying to generate it with AI, with DALL-E. I use a lot of DALL-E images because I think it's funny. And I got as close as the one I showed you, and then I couldn't get the fruit in, and finally I gave up and pasted it in. But here's the different questions. Does the fact I asked different questions change anything, do you think? Does that make me an author? Probably, but nobody knows. In the absence of specific language in a statute, what a court holds becomes a precedent. Now, there's three things in a court decision. There's findings of fact. What did the copyright people say? You didn't give us enough fact, no finding of fact, we can't make a decision. We didn't know what you did and what the program did. There's dicta. Dicta is the explanations for the decision, for the holding. And there's the holding, which is the decision. The only thing that has force of law is called the holding. So when you see these people analyzing court cases who are not lawyers, they probably don't know what they're saying because they don't understand the difference between findings of fact, dicta, and holdings. Maybe they do, but it's uncommon. Anyways, why is this important to us? Because there's not a lot of holdings out there. And without a lot of holdings, we can't tell where a court is likely to come down. It's an area of law that's in rapid evolution. It's complicated. There's a series of cases out there that deal with music that have to do with if you copy somebody's music style, do you violate their copyright? Yes, you do. Turns out, bunch of stuff on there. Now, go back to those images of the bear I showed you. Does DALL-E have a style? Oops. See how complicated it's getting now? That issue has not been resolved. Yeah.
Could you copyright the question as if you're writing?
You probably could copyright the individual question.
But I could copy the picture by hand then, potentially.
Yeah, the question is, what's in the picture, the question is, what did you do versus what the AI did? The question is yours, but is that sufficient to make for authorship?
Yeah.
What's your name?
Katerina.
Katerina goes to you and says, draw me a picture of a cat, and you make a picture of a cat. Does she own the picture of the cat, or do you? Who owns the copyright?
I do.
Because you made it. She just asked the question. See what I mean? That's all I did. I asked the question. Draw me a picture of a cat. Do I own it? I don't think so. Now, as I said, this holding likely applies to other work of art. So here's the good news for you, which you already know because you just had a presentation on this. You got copyright. Don't sweat it. Put the C there, but you got it. Secondly, I have no bloody idea what that means. Because just like AI is disrupting so many other things, it's disrupting law. I used to work for the Thai government. I spent a number of years working in Thailand. And I did a presentation in Thailand about 7 or 8 years ago saying AI is going to totally disrupt law. And here's why. And sure enough, it's happening now. So copyright of AI-generated art is in flux, and that's going to affect all other copyright. I can guarantee you that much. How it affects it, what happens, who knows? Some jurisdictions have registered copyright, some haven't, some have conditions, some have backed off after registering it. See what I mean? It's in flux. Again, authorship and originality, that's what it's about. The more you can show those two things, the safer you are. And sooner or later, there's going to be legislation probably to resolve this. I'm not sure courts can resolve this on their own. That's an interesting question. Now, how are you people with profanity? Anybody got a problem with profanity?
No.
Good, because I'm going to swear. We do this in America. It's part of our common language, particularly since Donald Trump. Why do you give a fuck? One, you have to know there's an infringement and take affirmative action to enforce it. A lot of money. The best you can do is write a letter on your own or send an email, which they go, delete, never got it. Send a letter, registered mail. Did they do registered mail in Cyprus? You have to sign that you received it. Okay, send a letter, registered mail if you're doing it. They got it. They say, well, screw you. What do you do then? You say, how much money's involved? Is it worth pursuing it? Because I have to pay the lawyer, because unless you're really, really famous or it's a really, really high value work of art, nobody's touching it on a contingency fee. Cash on the barrelhead. Can't guarantee we'll win. Sometimes they can say good odds of winning, but they'll never say you're going to win. Because they don't want to open themselves up to malpractice claims. Why wouldn't you win, even if it's open and shut? Anybody familiar with this one? The Warhol case? I love this one. Question. Is this a new work of art or not? Or is it a copy? It all comes down to how much of this image you can use in making a new image, and that's called fair use. Is this enough originality and authorship to change the image? We don't know what the answer is because it's in litigation.
How do you judge that? I mean, how do you judge if something is significant or not? I
can judge it. You can judge it. She can judge it. You're my friend. You're going to be my example from now on. Poor Katerina, she said, why did I sit in front? Who knows how the judge is going to judge it? There's a famous saying from a Supreme Court justice in America in a case involving pornography. He said, I can't define it, but I know it when I see it. Yes, sir.
I get the feeling that when it comes to art, there are some very special cases of artists that you can actually distinguish if it's their own art.
Style, right.
There is a style. And Warhol, for sure, he had a style.
Yeah, but is this enough Warhol to say it's different than this? I'm not sure it is. I have a real problem with that. It's one thing for Andy Warhol to paint abstractly, not abstractly, super realistically, 2 cans of Campbell's soup standing on top of each other, because you look at them and you say, that is not what I buy in the supermarket. Don't look like that in the supermarket. I know, I bought Campbell's soup. Everybody in America's bought Campbell's soup. Warhol's cans look like Campbell's soup, but he has abstracted out the essentials of it to make it that way. All he did here was put a color filter on top of it. Is that really Andy Warhol? Well, yeah, but so, is it really creative? My 3-year-old granddaughter does this kind of stuff. I don't know if that's enough. We'll see what the court says. Yeah.
I was wondering, in film and stuff, they often copy shots or a sequence of shots from other film, and they say, "Oh, it's an homage." So
yeah.
Where does that go between?
Think of it this way.
Or is that just?
No, that's fair use, and it's probably okay because it's this little tiny piece embedded in everything else. It's paying homage to whoever did it. But it's 15 frames in a 3-hour movie or a 20-minute documentary. Really? Not such an issue. When in doubt, get permission.
We discussed, we started by saying that it becomes important, the IP, when there is money there involved. So in this case, for example, as Andreas said, it's very difficult to define the style or stuff like that. But from that image, you are utilizing, let's say, the perception of the public that this might be Andy Warhol. So everybody knows it's not. But because of that, you get money, commercialize.
No, actually, what's going on in this case is the person who took this photograph is saying, Warhol made this, people are selling this, wait, I'm not getting my cut. There's money involved, I'm going after it. That's what this case is about. It's all about money.
So what happened with this case?
We don't know, it's still going through the courts. Anyways,
what's taking so long?
Courts are busy.
It's really interesting in terms of, excuse me interruption, but in terms of IP, when people say we want to own the IP, the question is not that they want to own the IP. The question is actually what they want is a cut of the money. So sometimes don't just think about what's the IP position on this? Think about what the potential revenue opportunities is. You could retain the IP and say, okay, if anything further happens with this, we will give you a cut of the back end. So
that's what's going to happen.
It's always the money thereafter. You want to be able to do lots of interesting, creative things out of it. The other party always pretty much wants the money. So just think about what that might look like, but we'll come to that later on. Okay.
Think about it this way. I'm going to build upon what she said because that was very important. When you make whatever you make, it's an asset. An intellectual comes out of your mind, asset. Assets are anything you can use to make money. They show up on the balance sheet of your business, you as a business. When you make money, it goes on the income statement, which is where revenues are recorded. At this point, it's just potential money. All IP is a way to say, I'm protecting this asset and saying it is mine. I'm taking affirmative action to say it is mine. There is no IP without an affirmative action. What's an affirmative action mean? Excuse me, Katerina. Stay off my property. Get off my property. Don't you see the sign that says no trespassing? Trade secret. Must have NDAs, non-disclosure agreements. Don't tell it to your mother, your daughter, your sister, your brother, your wife, your husband, your boyfriend, your girlfriend, anybody who doesn't sign an NDA. You know why? Because you've disclosed it publicly otherwise, and you go in a court of law, and the smart lawyer will find out you were telling people it can't be a trade secret because you disclosed it. You must take affirmative action. Registering it is a higher level of affirmative action. So it makes it easier to enforce. Yes, ma'am?
Doesn't this idea of taking this photo and putting it in the context of art have value in itself? It's like taking the soup and putting it into art.
Well, the concept itself, this is art. This is a different kind of art. If my 3-year-old granddaughter does this.
But she didn't.
Wait, if she does it, nobody cares. Let's say she does it. Do you think this person cares that my 3-year-old granddaughter did it? No. They're never going to hear about it, number one. Number two, what are they going to sue for? Where's the damages? She's not making money off it. So all this stuff is only important if there's money. That's the takeaway that I'm trying to get you to realize. You don't bother with it beyond what you get automatically unless you think you're going to make money. And I'm not talking about the kind of money I can rent my apartment, I can, go out for a dinner, I can do that kind of stuff. I'm talking about money. Big money, yeah.
But for, let's say, with music and style.
Yeah.
I think it's in the US, I'm not sure if in Cyprus, but you could register the harmony, the melody, and the lyrics. But how can you how can you take affirmative action for protecting the style?
If somebody violates my copyright, I sue them or I threaten to take them to court. That's what we call litigation. Litigious societies tend to threaten litigation. I come up to Katerina. I am in your face, aren't I now? I'm talking in her face. Are you feeling threatened? You say, yes, I am. Yes. I'm very threatened. Very threatened. She says, back off or I'm going to take you to court for assault. That is an assault. I get in your face, I start swearing at you. It's an assault under common law. I'm transgendered. I know this. I've had to experience a lot. You know how transgendered people take care of assholes? When they come up and they be an asshole, there's two things you do. The first thing you do is you say, if you're gay, it works there too. I can see you have a problem with me. I'm glad it's your problem and not my problem. Hopefully it shakes them enough that they don't know what to do. If they don't do that, I can do this, you can't do this. I say, by the way, I'm a member of the bar, I'm an attorney. I'm going to sue your ass so much that you'll regret that you ever harassed me. That stops them fast. Kicking them, punching them, doesn't do any difference. They just beat the shit out of you. And now you've committed a battery. Threatening a lawsuit, boy, you'd be amazed how fast even assholes back off. Anyways, let's go back to this. Yeah.
In art, you could say that someone's art style is his character.
Right.
But there's not many laws protecting that because that's what blurs the line in the AI art. Like there's no law saying that if someone comes and gives a commission to you to do a painting
in the style of
Picasso, you can do it.
Yes, but it becomes a question of whether it's sort of generically in the style or a direct kind of copying of what's going on. In this case, you're right. This person's saying, This is my style. This is my image embedded in the style. You look at this. If I say this was a Picasso, you'd say, no way. You say Warhol, you go, okay, I get it. Yeah, I could see it being a Warhol. My 3-year-old granddaughter, you're like, oh yeah, sure, it's a Nana. Lana made that. I can tell. Yeah, who's Lana? You know, it's like, it means nothing. But again, it only matters if there's money involved. But a court will look at style as part of what's involved in a copyright infringement. How about this one? See this? This is a Lefkara lace. We all know this painting, right? Everybody who's been to Lefkara knows this. They tell you this story in every shop you walk into. This is new. I took a picture of this when I was there. Is this fair use?
Yeah.
You think it is?
Fair use.
Why? Doesn't matter. He's dead. He died a long time ago. Copyright's expired. Copyright's only good for your life plus 70 years, 60 years, whatever the jurisdiction is. Who's going to sue? His descendants? I want 1/8 of a 1/10 of a 14th of a percent. Because he's probably got a lot of descendants by now. When did Da Vinci live? 1400s, 1300s, somewhere around there. Da Vinci copied the pattern. He saw it in Lefkara. He can't hold the copyright on that pattern. He's infringing. Except for he's not infringing because it's a commonly used pattern. And besides, they're totally different images and totally different medium. And if you look closely, it appears there are some subtle differences between what's in the Last Supper and what they're doing there, even though everything is called a Da Vinci pattern. Yes?
But there are ways of registering rights to your descendants.
Oh, yes. Oh, yes. Oh, yes. But my point is here is that copyright only matters until it expires. And it only matters if somebody thinks they can make money at it. Yes, ma'am.
I'm sorry. Can someone say that if it has expired, but the descendants feel that it's not appropriate? For instance, let's say they use something for pornography and they don't like it. Can they do something? Something you understand?
I'm not sure if this is the right motion. Somebody said, "Don't ever do this in Cyprus." Yes, that's the right thing? Yeah, that's the reality. Too bad, you know? You got no right. Yes, sir.
Disney recently lost the rights to Peter Pan, I think, and Winnie the Pooh.
Yeah.
The copyright that changed.
Yeah.
And there was a big horror, which they made the laws to help them keep the rights all these years.
Right.
I mean, I know about this case if you want me to talk about
it. Yeah, sure, because I know so well.
But basically, Winnie the Pooh, Disney had the rights, but last year they lost them, and this British filmmaker made a movie called Winnie the Pooh, Blood and Honey, which is a slasher movie.
Yeah.
He could use Winnie the Pooh, but he couldn't use the red jacket because that was copyrighted by Disney over Winnie the Pooh. So they had to go through breaking down Winnie the Pooh as a character that Disney added on, and he couldn't use parts that Disney had copyright. So Disney had the copyright on the red jacket of Winnie the Pooh.
Right. That's how people extend copyrights, and they also extend patents that way. It's called fence posting. You have a core copyright or a core patent, and then you fence post around it by adding other stuff.
It was kind of the same when Marvel Studios didn't have their own studios, and and Fox owned X-Men and Spider-Man, and they'd have to do a film every 3 years, or they'd lose the copyright and it'd go back to Disney, and that's why a bunch of films being made.
Okay, moving along. Trade secret. It's a unique way. We've already talked about it. I'm not going to repeat what I said here. Trademark as authentication. Got to be registered. I don't think it's really worth it unless you're going to be worth a lot of money. None of this is worth it unless you're doing something where you think you're going to make a lot of money. That's what I want you to realize. Because you already have copyright. So if you're going to make a lot of money, it's definitely worth it. If you think you might make money, it's worth it. But if you're just going to be selling cups in the corner or making documentaries that are shown as educational TV in only Cyprus, hard to tell. If it's going to go global and you'll be able to license it, that's your goal, different story. It's all about the money. Just remember that. It's like a good detective movie or story. You know what the key to a good detective story is, to the solution? Follow the money. IP is follow the money. Designs. Yeah, industrial designs make sense if you're doing that kind of stuff, making pottery that's being mass produced and all these other things. But again, it's just more, it's a branding technique in a sense. Here's my sporks. They're all unique. Everyone's unique. So you can design around anything. Realize that you can design around it. Trademark's probably more valuable than the design, unless it's something that's really hard to get around or so popular like a Winnie the Pooh or something like that. Or you're putting a fortune in, a big studio putting a fortune into promotion of it or something like that. Patents, I already told you about patents. If you are an artist, you come up with a new way of making ink, patent it. If you are an artist, you come up with a new way of curing clay, and you think others will copy it, patent it. If they can do it and you'll never know, trade secret. Bottom line, you already got copyright and trade secret. You might want to think about trademark, but it's probably not worth it. None of it matters unless you're going to make a lot of money. It's got to be hard to get around, doesn't fall under fair use, and if you're not willing to monitor and enforce it, forget it. It's useless. I go walking, well, one dog, unfortunately, I think is going to die tonight. But I have two dogs. We go down to Larnaca and walk on the beach, and we are trespassing, I am sure, most places we walk. Because we drive down to the beach on these little dirt roads, and it doesn't say Cypriot National Park or, dogs allowed. It's just a dirt road. And we get out and we walk along the beach and in the grass and all this stuff, and the dogs run around. We're trespassing. Nobody seems to care. I don't care. I'm trespassing happily. I'm a lawyer. I know I'm trespassing. Doesn't matter to me. You come up to me, I'll say, oh, okay, I'll leave. Thank you. I'm sorry. I didn't realize you didn't want people here. It wasn't marked. No C, no trespassing sign, right? If there was a no trespassing sign, I went to it. Probably couldn't read it. I have to take it in picture and Google Translate to make sure I understood it. Anyways, if somebody is infringing you, write them a polite letter and ask them to stop if you're aware of it. Better, have a lawyer write it for you, not me. You need somebody who's a member of the Cypriot bar. So it looks real, and they probably should write it in Greek if you're in Cyprus. And if it doesn't work, forget it, unless there's money involved. That's the reality. And again, patents are possible. It should be a machine, a method, a process, a material, something like that, a product or industrial design. Novel, non-obvious, not previously disclosed, useful, reduced to practice. You have to have a constructive reduction to practice, so somebody who is knowledgeable in the field can do it. And then if you still got to license it, monitor enforcement, there's patent maintenance fees. Patents are expensive. If you are in the position of trying to patent something, the RIF Central KTO may be worthwhile going. We will have something called a patent voucher, which helps offset the cost of patenting, but only if the experts there think you have something that's worth spending the money for. This is a Maria pot, famous among collectors of First People's art in America. I happen to be one of those. This pot here is worth $15,000. This pot is roughly that. In 1969, I was 18 years old. I used to drive across America all the time. And I was working up and down what we call the mountain states. as a cowboy. This is before I transitioned. I was actually punching, we call it punching cattle. You actually don't walk up and punch the cattle, you know, but it's called punching cattle. I was punching cattle as a living. Then after a couple of years, I went back to college. But it was fun while I was out. I saw this pot. I loved it. It was $100. I thought, I can't afford it. Who pays $100 for a pot? Should have bought it. But of course, I would have had to lug it around for what? Gazillion and a half years. But the trick is how she makes her clay. She gets it looks phenomenal. Anybody can copy this. If you're not one of Maria's descendants, nobody makes clay like that. It's like the recipe for Coca-Cola. If she patented it, everybody would be making pots like that. And they'd be coming out of China at half the price with her name on them, right? So as a poet, I will give you a closing thought, which is most of us are not renowned or likely to be, or do you have children? My poem is called Why Bother with IP? When the work of living is art, work becomes complicated by the art of work. Pride in the work should be divorced from the price of the work. Still, when the work of living is art, work becomes complicated because a fair wage for this day's work is never known till you are dead. Thank you for being so much fun. I will answer any questions you have and try and be responsible. Here, I'll let you turn this off. Yes?
So we've established that it's quite complicated when it comes to design or when you, like in the case of a Warhol-like creation. What happens with writing? And because you're a poet, like for example, if a poet is, let's say, inspired from another poet, and they might reference part of his or their poetry into their own poetry, where is the line when it's fair use or not?
Again, we come back to this issue, and it's very hard to describe an answer generically because the generic answer is when there's enough originality and authorship. That's all you can say generically. I'll give you a concrete example. There's an American poet named Wendell Berry. Probably nobody's ever heard of him in here. He writes what's called Sabbath poems. Every Sabbath, he's a farmer. Every Sunday he walks around his property, or did for years. He's old now. He may have died even, I'm not sure. And he wrote a short poem called a Sabbath poem. Now, I've lived a lot of my life in rural areas, and after I retired, I bought a redwood plantation. I raised, if you go Google redwood trees if you've never seen one. The trees here are small. These are trees that are taller than this building. They are bigger around than from this, well, from about here to there. That's a mature one. They're about several thousand years old, the big ones. You cut 1 or 2 a year from your plantation. That's all you cut, and you make enough money off of that, and then you plant them in over several generations, everything recycles. It's a real delightful, sustainable kind of forestry. And I would walk around my forest, and I had 200 acres. I'd walk around my forest and I'd write a Sabbath poem every Sunday in the style of Wendell Berry. Same meter, same pattern of rhyme. It was an interesting exercise for me, and I found it very meditative. Wendell Berry didn't write in redwoods. He wrote in Kentucky, in fields. He wasn't raising trees, he was raising crops, corn or whatever. Am I copying him? Probably not. Am I being inspired by him? Definitely.
Can you claim the technique?
What?
Sunday walking, can you claim the technique?
Probably not.
No.
with the head of security for the Queen, for the royal family. Scottish fellow. Sounds like Scotty in Star Trek. He's like, you know what keeps me up at night? I'm like, no, I don't. What does keep you up at night? It's the terrorist. A terrorist comes up and he's got the bomb strapped to his chest. And he comes in and we stop him and he pulls the thing and it goes off and we kill everybody. 500 civilians get killed. All right, let him kill the Queen. I don't know what to do about it. He says that, and I say to him, because I'm good at this stuff, I did this for a living, I said, how does a terrorist bomb work when they're all strapped to the vest? And he says, well, you got your explosives, and you got your wires, and you got this, and that, and there's an electrical charge that generates a spark, and it goes boom. I didn't know that, so he's contributing, right? I'm going, what kicks off the electrical charge? It goes a cell phone. That's all they need is a little cell phone there, and he's somewhere else. The terrorist, he dials the number, boom. I go, I know how to solve the problem. He goes, really? I said, what do you think of this idea? There's a thing called inductive coupling. It's very common now. Back when I was working in inductive coupling, I was a contractor for the US Navy, and we were charging up underwater drones from submarines to charge the battery, and the drone would come up next to the submarine and they would send a current across with inductive coupling, just like you stick your cell phone on that little pad today. So I'm like, if you could run inductive coupling in reverse, we could drain the cell phone. Everybody, it's like, you know, I've met presidents in the United States. When you go meet a president, it's like you go through the magnetic machine, you know, it's like beep, beep, empty your pockets, you know, it's like going on an airplane, same kind of thing. So I'm like, that's all we need is one of these things, you know, beep, beep, but only in this case, we're like, don't go through it if you have a pacemaker, because we're draining all the batteries. You can leave your cell phone at home or you'll have to recharge it afterwards. We're draining every battery that comes through here. If you want to get in to see the Queen, that's how it works. He goes, yeah, we can do that. We can do that. People are crazy in Britain. They like to see the Queen. Okay, so I go back and I call an expert I know at Oak Ridge National Laboratory, who's an expert on this induction stuff. I go, can you run it in reverse? He goes, yeah, this is how I would do it. Co-inventor, the Scottish guy is co-inventor. Three of us come together. We've actually figured out how to disarm a terrorist bomb over a beer on a napkin. The other guy wasn't there. The two of us, you know, plus the other guy, though, he contributed too. We go in, file a patent, go to the Department of Defense. They say, thank you. You know, good, national security. Who knows what happened to it after that? Actually, I do know what happened to it, but they'd kill me if I told you. Anyways, my point being, those two guys, it wouldn't have happened but for them. They're co-inventors. Somebody else who says, gee, we'd like to disarm, if all he said was, we need a way to disarm terrorist bombs, not a co-inventor. You follow? Take that, apply it to art, same thing. Final comment in that regard. If you're doing work for hire, make sure the contractor, you're hiring somebody else, read the language. Because what you own, if it says work for hire, every court knows you own no IP. That's jargon.
I wanted to ask this. If you do work for hire and you don't have a contract, then automatically whatever you produce belongs to the person who hired you.
No, belongs to you. You own everything you create except your children. Unless you give the right of way in a contract, and the rules of any contract apply, which means there must be consideration. You must get something back. They say, this is a work for hire, I'm not paying you, no consideration. They say, this is a work for hire, I'm not paying for you, but I'm going to promote your name in big bright lights and you're going to be on TV and this consideration, you know. They would say, okay, instead of money, I'm getting advertising and all these other things. But there's got to be a quid pro quo. You can sign a very bad deal. It's a free country. You can screw yourself. But there's got to be consideration. Yes?
You could, on a work for hire agreement, you could, like for an artist that's going to appear in a TV show, a music artist, and she's only sung the song, she could get €0.
Zero royalties, yes, or payment.
Yeah.
Yes.
For the work for hire.
If it's a work for hire, they say, I want you to write a song.
Just perform the song, not write it.
Well, she may not own the rights if she's just performing it. That's a different question. So she's labor. There's no intellectual property involved there at all.
Her likeness.
Is she a very famous artist? It's Madonna. I don't know who's famous now. I'm old, you know, I don't.
Sorry, I didn't understand. So, I'll give you a scenario. I have a company, I hire a photographer, I pay the photographer to go and do specific images for me, for my project.
Right.
But I don't have a contract with this person.
Photographer owns it. Owns the right.
Even if I paid them.
Even if you paid them.
Even if you paid them?
Even if you paid them. You probably write in the contract, I have the right to use this image in my movie. They own everything else. Think of intellectual property like this. Anybody's parents or any of you own a house. Everybody understands what it means to own a house. When you own a house, literally own it, you own it what's called fee simple, meaning you own everything. You own the house for perpetuity. Nobody else owns it. Somebody comes, knocks on the door, you go, you're trespassing, go, get away, I'm calling the police. You have that right. It's your house, your property. Now you say, it's a group house. I'm going to pay for it by renting out rooms. I rent a room to Katya, I rent a room to Adonis. See, I'm getting Greek names, I'm doing it, okay. I rent a room to 3 people for 1 year. I sign a lease with them. You lose the right to those 3 rooms insofar as it's specified in the lease. If you say, you have these rooms for 3 years and you don't specify I can come in to fix the plumbing, you can't come in. You could ask their permission. If you write in the lease, I have the permission I am allowed to enter in order to fix the plumbing, then you can. Right? So I'm slicing and dicing up the rights in time and location in the house. What do we do in intellectual property? We slice and dice it up. Typically, the rights we slice up are the right to make or copy it, use it, or resell it, or sell it. Make, use, and sell. Those are the 3 most important rights. Why? Because that's how people make money, and nobody cares about intellectual property unless there's money involved. Sometimes people care about intellectual property so they can go, I got a copyright, I must be important. Usually you see that more with patents. You see that a lot with patents. I'm important, I have a patent. Important, not impotent. Anyways, you can slice and dice it up however you want. So in answer to his question, he's not going to write a contract that says, I'm going to pay you to do a photo shoot and I can't use this for my movie. That's going to be in the contract. Be careful, everything is in the contract. That's the point that was made earlier by my colleague. Because all the court will look at is what's in the contract. Anything else, good luck. You say X, they say Y, who do they believe? They say, we don't know, we're just going to look at the 4 corners of the contract.
Two kind of questions in
Sure.
different, let's say, contract. You're working in a company, you're a creative, you don't have a contract with a company, because in Cyprus this is like really usual, really common. Nobody got a contract with a company. You create something that was not used for a client. Is it yours?
Yes.
It's not companies.
If you create something that's used for a client, it's yours. You own it.
Even you, not the company, not the agency.
Sign a contract.
No contract, you own it.
Even if you're
What if the company, let's say the agency sold it to whatever, the client?
Right.
Great, you can sue them.
There's an interesting question whether you can win on that if it is the core of what you're being hired to do.
Okay, that's what I'm asking. Even if you don't have a contract.
The core, I can't answer this because I'm not a lawyer in Cyprus. In the US, it is possible if you're working without a contract. First of all, nobody in the creative business in the US would hire you without a contract. I mean, unless they're crazy. Because we're litigious. Here, nobody fights over anything, right? Everybody's best friends. So a court, I've lived here for 6 months. I'm starting to learn how the game's played. You notice I have a steel vest on my back. Anyways, a court is likely to infer if your job is creating the job definition you signed up for is to create works of art that are used in advertising for clients. They're likely to infer, because you accepted implicitly that job definition, that there is an implicit work for hire contract. I don't know if they do or not here.
And you took the money.
but
you were paid.
And you were paid.
And you were paid regularly if you were on a monthly contract.
So you could have left if you didn't like what they were doing.
It's not your IP.
Probably not, but we don't know.
Can I add something? A personal case. I used to work for ABC News, US, in the 90s. And I was going to produce a documentary that needed some of the footage that I filmed for ABC News. Contacted a lawyer. I don't have a contract with ABC.
Right.
Hired me as a freelancer back in the 90s to go and shoot in Yugoslavia during the conflict. The lawyer said, because you were hired specifically for a specific purpose, even though you do not have a contract, they can dispute the ownership of that material. And it would be more advisable to get the permission to use it for my own purposes.
They will infer it. Sometimes, in the US, anything done by the federal government has no copyright by definition, so you're free to use it.
Public domain.
It's public domain. But whether it's public domain or not, I don't know how it works in Cyprus. I've never asked that question. I make videos myself. I make mine on, here's what you do to keep your house from burning down in a wildfire, because I'm a public information officer for a fire department and one of these incident management teams. When you get in your 70s, nobody wants you on the line. It's very sad. They think you're more of a hazard on the fire line than you are a help. They're like, oh, here, you must be tired. You take the first break and sleep. That kind of thing. It's embarrassing. So you go, okay, I'll go manage fires instead. So I join an incident management team now. I help manage these humongous wildfires you see when I'm in the US. It's a lot of fun. If you like adrenaline and you like helping people, nothing beats the fire service. Anyways, I make a lot of videos. Short videos, educational videos, or stay away from Route 20, and I edit these things. If I need to use somebody else's material, the city of Hard Luck in Eastern Washington, I'd go to the city and say, give me a letter that I have permission to use. They're like, oh, please use it. It's not a problem. But I get the letter. We have a phrase in the US. It's called CYA. Do they do this anybody know what CYA is? Do they do this in Britain?
I don't know well, you need to tell me what CYA is.
Cover your ass.
Yeah, we have Absolutely that on everything.
It's a CYA moment for you. Is anybody going to really sue the people who have come to keep their community safe? Highly unlikely. Could somebody be crazy and do it? Yep. Cover your ass. If I'm covering mine, you should cover yours.
I'm in a copyright lawsuit at the moment with an old employer. Like we finished a project, they used my pictures in the project. I have a signed contract that I keep the copyright.
Okay.
And 5 years later, they decide, no, let's put the pictures in an application.
Right.
And that was not part of what we did.
Right.
But they claim now that it was part of what we did. How can I prove that it's not?
I do not comment on ongoing lawsuits because I am not a lawyer in Cyprus and there are legal liability for me in responding to your question. So I am sorry, but I will not respond.
And she is covering her ass.
I am covering my ass.
So, thank you very much, Phyllis, for your presentation.
Thank you.
Okay, what we did this morning was all the underpinning of what you need to know if you're, in the creative sector and things that you might not have been aware of, okay? What we're going to do this afternoon is what I spend my whole life doing. I don't spend my whole life advising on copyright and trademarks and things like that. Not a bit of it. I need to know how it works, and I can't tell you how lucky we were to have Phyllis here today. What I spend my day job doing is having way more fun with people like you. Okay, what I spend my day job doing is helping businesses like you, like yours, find new revenues in what they already own. So you needed to understand what you owned before you could work out what you do with it. Unless, of course, you hire me and then I find out. And I'll find things in your businesses that you haven't even thought about that we can earn more revenues out of. There hasn't been a single person or a single company I have ever worked with where I have not found new revenues. So this is what we're going to do this afternoon. And remember, creativity drives value. So what we're going to look at this afternoon is what do you own now? What could you own? And as Phyllis says, how can you profit from it? And there are really, really interesting ways that you can profit from things. So let's have a think about what you own now. Okay? You will have been aware from this morning that there's going to be lots of copyright you own. But what this process is about is really about discovery and mapping. Okay, it's about really digging into your business and to what you do to think about this. And we've got several tools that we're going to use. And we're going to break it down into 3 areas. We're going to break it down into intellectual property and what I call intellectual assets. Now, I know if Phyllis was there, they're intellectual assets that the sort of legal term would be very different, but you'll see how I define it, and business assets, okay? So let's start with IP. Come on. Okay, so we know that these, and include trade secrets, we know these are the IP that you're talking about. So let's be clear. You own the copyright of everything you create, but it has to be something real, not an idea. We've seen this diagram before, okay? Copyright, automatic, trademark, design right, patent needs to be registered. Okay, so we've done intellectual property. We're not going to go through all that again because I think everybody might have a brain dump or have a brain freeze or whatever. Okay, so now we're going to talk about intellectual assets. Right, what I want you to think of as intellectual assets is everything that has got you or your business to here today. Everything. Okay? What is extraordinary about every single one of you that is in this room or walks past in the street is your journey to here is totally and utterly unique. Okay? Your journey to here will never be replicated in human history. It's never been lived by anybody else. It'll never be lived by anybody else again. So So why wouldn't you use that to do something new and completely different? And this is, okay, this diagram, we're only going to use a bit of it. This is how I get creative companies to draw up their business plan. We don't write it in a Word document, we draw it big on the wall. Now, what's really important is this top half of the diagram. Now, what you can see is the top half in little grey writing says internal, and the bottom says external. I want you just to sort of ignore the bottom at the moment. What's most important for your intellectual assets is the top part of that diagram. And we're going to look at it in a bit more detail. When I work with companies and when I work with boards of directors, I sit down and really, really dig into their backgrounds. I want you, as part of collecting your intellectual assets, to think about your background. Where were you born? Where were you in your sibling rate? What did you love doing as a small child? What were you good at? These all form the intellectual assets that are part of your business. And when you've got 2 or 3 people in the board, or 6 or 7 people in the board, you have the most amazing treasure trove of resource. People always forget to dig back into their past to find the resources that they can take forward into their business. And you just go, geez, why do these people not think about where they've come from and what they've done? The next thing I get clients to do is write a comprehensive business list, a comprehensive list of every single client or job, company that they've worked for since they were about 16. The reason that I get them to do that is because you will have been influenced, you will have taken that knowledge in some way, shape or form. So, when I was 19, I worked on British Airways advertising for the ad agency. I still have that knowledge about British Airways inside me, and I still think about how they did stuff on Concorde and everything like that. Concorde is a luxury brand, so, there's all sorts of interesting thinking going on there. I can still look at airline advertising, service businesses and go, oh, I can use some of my British Airways knowledge on this. Now, I don't think it out like that. It becomes instinctive. It's part of who I am. List those companies from the very beginning of your career. List companies of your, people you work with. This is knowledge that your business has. It's in their heads. It doesn't belong to my knowledge about British Airways doesn't belong to the ad agency I worked for. It belongs to me because it's been, spun around in my head. They're not trade secrets or anything like that. Now, what's really interesting is if you wrote those companies in a list that was chronological, you're going to self-limit in a way that is extraordinary. I realised that when I was working with clients that things that happened early in their careers, they undervalued. Things that happened more recently, they overvalued. So what I get people to do is write that list alphabetically, then it takes anything out of it. Now what's really interesting that you can use that list to find sectors to work for that you may not have looked at before. So somebody came to me and said, oh, have you got any experience working in the luxury sector? And I went, no, I don't really do luxury, it's not my bag. And then somebody went, hang on a minute, you said that you'd done some work for Concorde. And I went through my list and I discovered that I'd done some work for Concorde. I'd forgotten that a company I'd worked for I'd done some work for Mulberry. When I was 17, I worked in Asbury in Bond Street for 3 months, the jewellers. So hang on a minute, what's all this saying I don't do luxury? Actually, I've done luxury at odd points in my career. Okay, I can group these into luxury. Okay, do you see what I'm saying? Doesn't matter how far you go back, all of a sudden I can do some work for the luxury sector because yes, I've worked in it. I might not have worked in it yesterday, but I have worked into it through my career. So you can use that list in really inventive ways to find new sectors, interesting overlaps of skills and abilities. The third thing you need to do is to think about what you've actually been paid to do in your career. I've been paid to do a shed load of things. It's really useful to go through your skills and what you've been paid to do, because often you may just say branding, okay? But in fact, you may have been paid to do branding for a number of service companies. You may have been paid to develop a brand book for a charity. So don't just clump things under big titles. Really begin to break it down, because when you've got that list of skills, are you selling all the things that you've done to your existing clients? If not, why not? Okay, I go back through these lists. I redo the lists, sort of make sure about the end of every year, have I added a whole lot of skills? If I add them to my old skills, can I make something different? Can I repackage them, repurpose them differently? Can I therefore charge more money? What I'm consistently doing is revisiting my creative career, revisiting my business career, revisiting my coaching to see if I can repurpose things inventively to charge in new and different ways for them. You can do all the same. Okay? The next thing to think about is passion, skills and talents. Whoever sits down and works out what they're passionate about, what they're really skilled at, and what they're talented at. It's a really interesting list. And I'll tell you that when you get to that bit, all the men in the room go, do we have to? It's fascinating, and I absolutely can do that split. But actually, when you think about what you're passionate about, are you working in that space? Now, lots of people say to me, oh, we're passionate about food. It can be home or work stuff, but what matters is to understand what your passions are. I am really, really profoundly passionate about creativity. It is my reason for living. It is the reason that I do everything that I do. And anybody who meets me will go away knowing that that is what gets me up in the morning. It's here in my body. I'm passionate about the garden. I'm passionate about the creativity that I do in my garden. I'm really passionate at seeing my grandchildren understand the fun that can be had. I'm passionate about all your businesses. I'm passionate about the creativity in the clients that I work with. You know, sometimes it makes me cry because it's just part of everything I do. So, passions, what sits there? Skills, what have you learnt to do? Because those are very different. And then talents. Okay, talents is the great one. You are going to fall over talents until the day you die. Because you'll never know whether you're talented at something until you try it. And you might suddenly find there's an aptitude for it that you've got. Whoever knew that I would be able to walk into any business and find new revenue models from them? Whoever knew that? I suddenly find I can do it. Wow, it's talent that you come across. So really, really unpack that list. Then the other thing, which seems to slightly contradict the last two, is think about what's been going on recently in your life and what you've learnt about, okay? Because that actually can often influence, you know, it can give you a perspective on all the other things. Okay? So, you know, these are all your assets. These are assets that nobody in a business, no business I have ever gone into has ever used that lot, ever. And you sort of go, wow, what a waste. Now, I'm just going to go back a slide. What these things do when you're developing a business plan is all the stuff that's internal plays into your strengths and weaknesses in a SWOT analysis. Are people here largely familiar with a SWOT analysis? When you're developing a business, you do strengths and weaknesses, opportunities and threats. and most people do them down here in early days in the business plan, you need to do all of this first. Because how the fuck do you know what your strengths are unless you've written those lists? You might guess, but mapping them is a much, much better way of doing it. But it also highlights some weaknesses. Now, what's interesting is we've already had a conversation here this morning with two people who go, oh, money, finances, create a business. No, I don't do that. I hear that again and again with creative companies, that they put it in their weakness box. And legal, okay? Anything else that's in those weaknesses box, just put a big black mark through them, okay? You don't build your business on weaknesses, do you? You build it on your strengths. Okay, so if you've got a weakness for finance, learn about finance or appoint a good bookkeeper or whatever. Get a good, if you've got legal problems, make sure you have a good business affairs person on call. Right, okay, let's move on. So, I didn't realise I got this slide in here. It just shows the top half of the diagram. Okay, so what begins to happen as you do those blobs is your intellectual assets build this really, really amazing sort of store cupboard of stuff. And it could include methodologies that you've used, your passions, your skills, as we've mentioned, your life story. It could include, when you think about all the clients you've worked with in the past, you've got an amazing network. The other thing, you might have, part of your skills, you might have devised characters. How you live might be part of your intellectual assets. Your different experiences, the courses you've done, what you've been paid to do, the on-screen worlds that you've been playing in, because you know how these things work. The audiences you've had, the social media you've been on. Don't just go, that's over there. This is part of your intellectual asset sort of portfolio, if you want. I said that. Please don't underestimate how totally unique every single part of that is. It is very, very precious. You all have these amazing, amazing abilities and these store cupboards. Okay? I do what I do because when I was in a really, really shit place. Okay, so I went through a divorce. I ran a production company with my ex. He was the director, I did a lot of the admin, and I ended up being financial director. Having run design studios, I ended up as a financial director. I was really good at it because I was so fucking terrified that I didn't understand how the money worked. So I made sure I knew how the money worked. Went through a divorce, and I worked in that company with my ex-husband for 4 years after the divorce. It was agony. But I couldn't work out what else I wanted to do. And then one day I thought, this is so stupid. And also, if someone's going to divorce you, it makes sense that you're financial director of the joint company you own because you know where the money is. Okay, so what I realised was that I had worked across advertising, product and graphic design, licensing, digital. I'd worked in TV production. So I looked at my life story and I realised I didn't know anybody else that had worked across all of these different sectors. And there are a few more I haven't mentioned, but we won't go there. And I knew how the creative modelling worked, and I knew how the financial modelling worked. And I went, it's really interesting. There are things that they use in the TV sector that they don't use in the design sector. Why don't, oh, this is interesting. And that's how I came up with the work that I do now, because I realized that I could help companies make money in different revenue models in different ways. That's, 11 years ago, and I'm still doing that, and nobody else does it. So that's why digging back into your past can find you really fantastic ways of working and revenue. Now, this bit's a bit shorter. Business assets. Okay, what have you got in your business? Might be property, might be machinery, right, might be raw materials. For example, here, you know, they've got an amazing 3D printer. You know, they could hire out the 3D printer to do all sorts of different things. If you've got property, you know, you can do something different with that. So when you've got business assets, you can do all sorts of things with them when they're quiet and things like that. So always include those in your discovery and mapping phase. So how can you use your IP and assets inventively, unexpectedly, with originality? We're going to use cake as an analogy, okay? So just roll with me on this one. Okay, so this particular picture, what do you need to make that? You need, okay, this is where I always forget the ingredients of a cake. You need sugar, butter, flour, eggs, okay? And you need baking know-how. Right, what we're going to do is the sugar, butter, flour, eggs, pretend those are your intellectual assets. So this is a bit of a zhuzh cake. Imagine it was just a sponge cake that I'd made at home, okay? Because you need to do that for the story. I ought to make a sponge cake to put this photograph there. Okay, so a sponge cake, probably if I made it in a village fete, would sell for, I don't know, £2. And largely, the time of consumption would be, you know, maybe in an hour or so's time when you have a cup of tea and you just need a little bit of something sweet. Okay, so the hour of consumption is probably around tea time. Okay, so £2, quite simple. Okay, now we're going to take two of the intellectual assets. So we're going to take sugar and eggs. Thank you for whoever's baking in here. Sugar and eggs. And we're going to use baking know-how, and we're going to make meringues. Now, meringues are used for dessert, maybe at a smart lunch, or maybe dinner in the evening when you've got family around for dinner or something like that. And, you know, sometimes you go into those delis in London and they've got these wonderful, amazing, puffy meringues. And, you know, they cost a fair old bit. So, you know, the value for them, the same amount of mixture, is probably about £8. So you've shifted your value from £2 to £8. You've shifted your time of day from tea time to lunchtime and dinner time to a rather more glamorous audience. So you can see what we're doing here, okay? Now we're going to make cupcakes. Same amount of mixture, and we've used sugar, eggs, flour and butter. We've added some real sparkly glacé cherries and zhuzhy bits. Now, we use those cupcakes. We might take them into the office. We might take them as a gift. They are completely different uses from those two, and they're in a different audience. So, you know, a gift, a present. In the office, again, you want to, you know, win friends and influence people. So you take those in. Now, those sell for between £2 and £3 in the UK each. So you've shifted the value of your ingredients from £2 to £8. You've made 8 of those, so we're up at about 20, 24 quid. Okay, completely different audience, completely different market. And then we have pancakes. They can be savoury or sweet. You know, they can be eaten on the go, different audience. They can be, you know, in a van at festivals, la, 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 la. Okay? The whole way through, you've used baking know-how. So, the ingredients. We had actual ingredients and intellectual ingredients, so the baking know-how. In terms of the potential purchaser, where was the market for them all? In terms of time of consumption, when might they eat it? How do they access this? Where might they find it? The value of the purchase, how much might they pay? Okay. Now we're going to add a bit of digital know-how. So we've done all of that. Who is familiar with this cupcake app? Anybody? Oh, yay, we've got one person in the room. Okay, an amazing, amazing cupcake app that you can use your phone to choose how you bake and decorate and generally do lots of magical things to a cupcake that children enjoy doing. Now, when I came across this, I went, wow, cake, well, cake mixture. Suddenly we've got digital know-how in there. Now, I absolutely could bet my bottom dollar that the person who invented this app, not built, was a baker. Because who else would have come up with something as ludicrously, not stupid, but as ludicrously ludicrous as that? And they then spoke about it to somebody who got app building. So to do something inventive, you don't always need to have the know-how, but you need to have, that idea. So this app, ingredients, they had baking know-how plus digital know-how. The potential purchaser, multiple parent or incidental game player, time of consumption, anytime, anywhere, more portable than a cake, point of access via smartphones, value of purchase, download fee, in-app purchase, extended brand. They now do pizza as well, should you want to know. Cake teaches you that you can repurpose your asset in any which way you want, okay? What's really fascinating is don't always think about the end thing. Think about how can you use all those ingredients in different ways. I use my ingredients in different ways. So I wrote a book. I have a methodology that uses the ingredients that I use every day in different ways to charge different clients, different audiences, and things like that for what I do. You can repurpose your assets in exactly the same way, but you have to map them effectively. You have to discover them and map them really, really effectively before you can do that. And you can create, and we're going to talk through some of this afternoon, you can create new intellectual property. I wrote a book out of my existing intellectual property, okay? I've got a course on Domestica with my intellectual property. There are new business models. I work with 50 different revenue models, okay, with all of my clients. You can find new audiences like we did with the cake mixture. There are people, all sorts of different people that are out there really, really interested in what you can offer them. And you can find new products and services that you can create out of those assets. So this was my map that I did on the floor of my IP. Okay, so copyright. What did I own? Okay, home furnishing and garden accessories. These were all my home furnishing and garden accessory designs, or some of them. This was my catalogue. I own all of these things, okay? I wrote a book. Okay, this was what do I own, page 2. I own the name and the title, the design style, colour palette, that was a question mark, written content, diagrams, cover palette. I own the reproduction rights, the media rights, the moral rights, hashtag, social media posts. These are some of the diagrams, and we're going to talking about money. This is my financial diagram, so we're going to talk about that later. Blog posts and articles. When this was launched, I wrote 200 plus articles written between January 2019 and April 2021. Oh my God, I was fed up of writing. Okay. What? No time for baking. So business growth coaching and IP development. There was methodology and practice. This is the model that I follow with clients, applied through practical working, coaching, speaking at events, running workshops. Each generates new copyright. Okay? I have, at that stage, between 350 and 400 clients. Therefore, I was asking myself, what other IP have I built up from this? Okay, so talk decks. Still on copyright. Notice page 4. At that stage, I had 4 talk decks. So this was one I love, How to Age Bravely. Unlock Your IP, Ideas for Surviving a Business Crisis. Tough Talking, How to Grow a Resilient Business. Okay, that was about money. Making more with what you own, and et cetera, et cetera. Trademark registrations. These are the trademark registrations I've got. This is one that I've used that we're going to talk about later, intelligent creativity. Okay, there is a real way that you're going to be able to extend your businesses, and we're going to use that. Design rights, haven't got any. Patent, haven't got any either. So now I know what I own. Okay, you can do that same sort of map with stuff you own. I have it up on the wall. Every so often, the ink gets really faded because the sun pours into my studio. And I redraw it again, and I find new stuff. And it's sort of, you know, your own creative process. And shall I tell you something? It makes you really proud of who you are and what you do. How many people have we got in the room here today? 30, 40, I don't know. That's an awful lot of intellectual property and assets. It should make you really proud of what you do. Because sometimes it's really tough in the creative sector. But actually, it's just a brilliant, brilliant place to be. You know, if you think about somebody working for, I don't know, some big brand, they don't do what you do. They're not brave like you're brave. They're not courageous about putting their heart on the table every time they present something. You know, God, guys, you are fantastic. But you've got to make sure you know who you are and what your assets are, because that's the core of who you are and what you can offer. So, we've talked about what you do own. Now, what could you own? So this is going to be about market trends and creativity. You need to be inventive. Okay, so get that radar switched on now. Because you've got to think about what you own, as we've discussed. We've got to think about how you could use it in a new way. We've got to think about what additional audiences you could reach and where what you own might have additional values. Okay, I've got some case studies. I was asked to work with an editor, a really experienced editor, film editor in the UK called Andrew Quigley Films. And he had moved down to Cornwall, away from London, and he said, you know, I need to find some new revenues. I don't want to stay editing for the rest of my life. We've never met. We were only on Zoom. And anyway, we were talking about all sorts of different revenues. We had a whole range of sessions in the book. And about 5 minutes into session 2, I said, "Oh, how are you, Andrew?" And he went, he said, I'm editing a big series, reality series for ITV in the UK. And he said, "Fucking hell." And I went, "Oh, okay. Obviously not a good week." I said, "What's the problem?" And he said, "They just send me the fucking rushes in such a mess." His quote. And I went, "Oh, do they? I've run a production company, remember?" And he said, "Yeah." He said, "The rushes are all in a mess." He said, all the time codes are in a mess. You know, there's no standard format for anything." And he said, in the last edit, it must have cost the production company an extra 10 to 20 grand paying me. And I was only one of 5 or 6 editors, so they must have paid that to them as well. And I went, I said, "Really interesting." I said, "Supposing you put together a training program called What Your Editor Needs, and you got all the shooting APs, development shooters, everybody to sign up to this. We train them properly, and you run that training program, and you can do it in person, you can do a hybrid version, you can do it online." And I said, "You know, that's going to be you earning money while you sleep." And he went, "That's a really good idea." He said, "Why don't I ring the head of production at Tinopolis, which is one of the really big production companies in the UK, and just float the idea past them?" He hadn't even finished the first sentence when she said, "Yes, how much do you need?" Because she realised how much money was being wasted. And effectively, her commissioning him to train her 8 APs on that shoot he was about to start working on saved her the money, and also it paid for Andrew to develop the course. My son runs a an indie production company in London. And I rang him and went, would this be useful for you? And he said, when's it available? So Andrew turned it into an online course within about 6 weeks with the help of his son. So I haven't spoken to him for a while because he's so busy on the edit. I don't know how it's going, but you know, we're also breaking it down because his son, who is 18 and had just started at Falmouth doing media studies at the college there, had said, well, why don't you break it down into little bite-sized chunks with stuff that's not taught in college, like, you know, how to do a white balance in your camera. And, you know, you could just charge 25, 30 pounds for that little bit. That is repackaging stuff that he'd known for the whole of his career. Okay, Donna Wilson is a designer and she's ex-Royal College of Art. She makes these lovely little stuffed characters like that. She also does lots of print patterns and things like that. She's knitwear, print and patterns. When I was working with her, I said to her, you know, because her patterns spread over a really, really long career. And I said to her, how many flowers have you designed in the whole of your career? And she went, oh, I have no idea. And I said, how many trees? And she went, oh, I have no idea. And I said, well, are they grouped together anywhere? And she went, no. And I went, why don't you build an element library? This is stuff you retail. This is a really expensive, bespoke, commissioned pattern. But there's an audience in the middle that could just buy stuff you've already done, so could buy elements. So we created an element library. This is just a rug of trees that she did as an example. Okay, there are always assets in your business that can be reshaped in different ways to find a different audience.
I was watching some videos on passive income about animators or 3D animators and modelers, and someone was saying something close as in like, oh, I model a city, I upload it, but then while modeling the city, I model certain parts to be extracted from that. So I have also smaller, cheaper kind of like, vents, air conditioners, whatever, like trees, and they're all like singular elements or smaller packs, and then you can also buy the whole city as a it's absolutely. I have got clients that are doing that. I think I've probably got 6 clients doing the equivalent of that at the moment. So, you know, drone footage or, you know, builds in you know, all sorts of different modelling systems. And I've got one which I'd love to be able to tell you, but I can't. Okay, so this is a very different way of thinking about what you could own, okay, and where there's revenue. Pause is when I did this diagram, and I worked with them last year, Pause was the equivalent of sort of Netflix for short films. So they had a market for short films. You could upload your short film, you could watch lots of short films on it. There was a tip jar, it was incredibly effective. Then they decided they were going down the NFT route, and I've now discovered another revenue. I got an email on Friday in which I went, oh, what's this? Oh, they discovered other revenues. But what Pause, the issue with Pause was they were a platform. They didn't own any intellectual property, and they brought me in to say, what could we own? So what I identified was that Pause at that particular time had 4 sort of players on their space. They had the audiences, global. They had filmmakers who were uploading the films to their platform. They had a lot of festivals coming there, and then of course they had themselves. Now what I did, and again it's a really, really useful model to think through this, you'll see that it's exactly the same list on both sides, but it's reversed. So what I did was I said, okay, what opportunity for building IP could there be in the relationship between the audience and Pause? What opportunity could there be for building IP in the audience and the festivals that are on your site? What opportunity could there be for building IP between the audience and the filmmakers? Now, it could be tangible IP, or actually it could just be a revenue model. And I drilled down into this, and I think I wrote a 45-page document.
okay, that went through all of these different opportunities for revenue, and I also looked at opportunities for copyright as well, okay? So, you know, this doesn't involve any spend at all in your business. All it does is need some time. And actually, with a lot of these things that I do, I realise that a big piece of paper, some really nice pens, and we have big paper and we have really nice pens here, and actually a glass of wine and a mate to do it with, who gets you, can often be the best way of exploring these things, because there's nothing written in stone. There's no guidebooks on this. There's no guidebooks on how you can create revenues. Radar switched on, all the different lists you've got, and then just let it flow. Let it out there. Talk about what if. We've got some tools that will help you. But this is what you can all find new revenues in these sorts of lines. Okay, what's fascinating when you begin to do that is sometimes you find interesting new revenues for your business, and this is what I find anyway. Sometimes you find interesting new revenues for your business or whatever. Sometimes you find something that can change a whole industry. I did some work for the Rambert School of Dance. It was wonderful. They asked me to come in and find revenues for them, and I did. But whilst I was there, you know, I know the dance industry a little bit. I've worked with the Central School of Ballet. But what I identified, and what was really fascinating, this is why having your radar switched on is so, so important, was that I identified 2 opportunities that could have completely changed the ballet industry. From a tiny passing comment that one person made. Now, I had to present all my findings and the revenue opportunities and things like that as I saw them to the finance director and the head of the Rambert School. And I identified these 2 industry changing things. They are still in my head. The head of the school said, we just can't do that. That's too big for us. And I went, what, even if I put together a team and make it happen? And they went, yeah, it's just too big for us. But I've now met somebody who's said to me, all those things that companies have said are too big for them. Why don't we do them together? And you go, okay, I quite like that idea. Because I knew the teams that could do all of these things, and I knew it was existing, all sorts of existing intellectual property or whatever. So, you know, sometimes the things that you see in your business aren't just products or whatever. Sometimes they're absolute game changers for a sector, and we'll talk about that a bit more in a minute. Okay, so this is a bit of a sort of new thing, and it's how you can really begin to drill down all those different things you've found. There are 5 things that people pay for a product. Okay, so what a product is largely something that you've had to create, you've spent the money on, you've developed, you make, and then when it's a finished thing, people pay for. Okay? So it could be a pair of shoes, could be a cabbage, could be a box of eggs, could be a festival ticket. You've had to do all that work and carry all the cost and all the risk until they buy it. Of course, there's always going to be bespoke, but, you know, most things are a product. And then we get to a service. So a service, as we all know in the creative sector, is where you're selling your time, okay? Now, I try and really, really get people that I work with out of selling by a day rate. Okay, what I try to get them to do, because clients will always try and push you down on a day rate, it's much better to charge as an output, because then you don't get hassled for a day rate. Okay, so if you can say the output is going to be this, and it really doesn't matter to anybody how long I take to do it, you know, you could end up, it might take you 5 minutes to come up with something. I mean, there's a great story of Dave Trott of Gold Green Lees Trott, who came up with he met some owner of a business at lunch who was bemoaning his ad agency, and Dave Trott said, well, you could do this, came up with a really, really smart line that sort of encapsulated a strategy, you know, a strap line for the business. And this guy went, that's amazing. Next morning he rang Gold Green Lees Trott, the ad agency, and said, you know, you've got my business. Dave Trott sent him an invoice for 250 grand. And he said, but that took you 30 seconds. And he went, no, it didn't. He said, it took me 30 years and 30 seconds. So, you know, when you're thinking about products and services, really, really think about, are you charging for the output with all that experience, which almost takes it into a product, or actually are you still charging the day rate? Try and get out of day rate mentality. The other thing, yes?
Is it okay to do one question at the end?
Yeah, well, whatever. If it's a question that's completely relevant to this.
It's just the day rate advantage, I would say, would be if a client keeps asking for changes and it drags out.
Yeah, so obviously, you know, that you've got to have a change mechanism in there, okay? And also, what happens is a day rate, often creative companies over-deliver. Who here has over-delivered? You know, has worked way longer. Who hasn't over-delivered is, yeah, probably an easier question to ask. But that change, a bill for change is really important, and actually understanding when not to, you know, when you need to stop, when good is enough. Okay, so a product or service. Okay, you can also charge for data/intelligence, which effectively is behavior. You know, it's really interesting to think about what behavioural modelling you can see in clients' work or all sorts of things. I mean, that without Urban Adventurers case study we saw this morning was just because I identified behaviour patterns in their clients. Okay, so really think about, is there any behavioural data or intelligence that you can see? Okay, that is you know, possible. Customer clients' eyeballs, you know, have you got a particularly great and fantastic group of clients or group of users or social media followers? You know, that's what influencers are paid for, it's their eyeballs, okay? So is there money to be made there? And then the final one is knowledge. You know, you can make money from your knowledge. So I write this list. It's a very simple list. But people have to be really inventive and really interrogate and interpret their intellectual property and assets to create the new, okay? So I get people to draw up a diagram like this. Okay, very simple. It's just a grid. And then I say, okay, if you are offering a service to your clients, and you can use it both as a breakdown, but you can also do it as a sort of forward thinking. So if you were doing, let's say, graphic design as a service for your clients, you put graphic design there and you break it down, maybe packaging, maybe branding, maybe, I don't know, maybe you're doing some animation in that. You just break it down, break it down, break it down. And then you'd go, okay, and I've got an example of where I've done this coming shortly. Okay, who are my clients and customers for these things? Who could be my clients and customers for these things? Or do I have some interesting clients and customers that I'm not offering these things to? And then you think about, what products could I develop out of this? So it could be, could you do a soft toy out of some of your animation? So what you're trying to do is just unpack everything and use these headings just to unpack really loosely. There are no rules. This is just a grid and a piece of paper. So be inventive. But what is really good is see if you can find yourself a revenue in every single column. Okay? So I have a revenue here. I have a revenue here. because various companies they like the fact that I work with so many creative companies, and they asked me if I could do things towards those creative companies. I have a product. I sell my knowledge. I've just started to earn a revenue here, because one of the things that I have done, as you saw this morning, I work with a lot of female founders. I've just been asked to go and work on another accelerator and to help them build their accelerator they've got an accelerator for female founders that's got seriously big money behind it. And they want to access some of the behavioral things that I found. It's not just knowledge, it's actually behavioral modeling as to what behavioral modeling I can help them with. So, it's a real challenge to try and find things in. If you just do 2 or 3, perfect. It's new revenues for you. I've only ever started working with one company that's been earning revenue in all those spaces when I started. So, and I went out and bought them a bottle of champagne.
I didn't understand what is Intel data. So
Intel data is behavioral. So think about all the data, is an algorithm type thing. Think about all the data that, Facebook is collecting. They turn it into a product, which is their advertising revenue. You will have a huge amount of intelligence and data in your business already. Every business has data. So I, for example, have lots of intelligence and data about the creative sectors. So I use that to think about how I can generate revenues that's out of my knowledge from the behaviors in the creative sectors that I work in. Okay, does that make sense? Okay, sorry, so what revenues could you find in each column? Okay, here's a story. And this just gives it a really, really clear illustration. I started working with Pod. Creative, they were sort of trade-only branded gifts. Okay, we've all been to conferences where we've seen plastic crap, okay? Again and again and again. Okay, however, what Pod did, they were sort of a tiny, this world is, there's really big companies that do it. And Pod was quite a little company, but it was a really quietly profitable little business that didn't need Mark to own it, to work in it that much. It sort of ran itself. But what was fascinating about it was a lot of the products they did was aluminium. Now, I sat chatting to Mark around some table in London. And when I said, well, tell me about who designs the aluminium products. Anyway, what I saw instantly was this man who said, oh, I'm, mid-late 40s, I'm getting bored with my business, I've fallen out of love with it, what am I going to do? Do I sell it? I saw this man suddenly sit up and start expounding the amazingness of aluminium to me. Oh, 75% of all aluminium ever mined is still in production. Aluminium's the only material that, if you repurpose it, doesn't degrade. Even if, when the paint comes off it, it can go from being a Coke can to an aeroplane wing in 6 weeks. It's an amazing material. And I went, how about we stop doing all the other stuff and just work with aluminium? And what we did was this breakdown. So, okay, product, Pod Packaging did branded corporate gifts, okay? The knowledge that he needed to do that included creativity, design, branding, printing, materials, particularly recycled aluminium. He worked with unique product manufacturers, so this is all under knowledge, and suppliers. He fulfilled needs, he knew what the needs were of his client. Because there were lots of big clients in it, it was a commodity market. The Intel data he was seeing on his website, corporate trend mapping he could do, how they purchase, different models of purchasing, their sampling habits. Service, he did branding and personalization. He had a short run capability, fast turnaround, and got involved in product design for them. His customers and clients were big distributors, brands, marketing. These were all tagged within an inch of his life on his mailing list. So what we did was we created a revenue out of every single one of these. Okay, so Branded corporate gifts. Okay, so we launched the company as 99% plastic-free, recycled and recyclable. It was the only corporate gift company in the UK to be doing this at that point. What was amazing was there's a big distributor model in the UK. And what was fantastic was when, this was about 3-4 years ago, and when Mark got in touch with the big distributors, because it was a commodity market, and said, would you be interested? They bit his hand off for it because nobody else was offering it. So it became, he put out this really different new offer for his existing client base and all his new offer, saying everything we do is going to be 99% plastic free and recyclable. Okay, so this was his knowledge. He started consulting with brands and small companies to go plastic free. He then started doing trend mapping across retail and corporate and really looked at who was buying what plastic free. He added both a direct consumer, and we'll see some of the products, and a high street offer, because he could do short run capabilities, fast turnaround, and he could product design. And he enlarged his database, became a thought leader, having identified unmet needs, and suddenly he was being paid to speak all around Europe. Okay? You see what we've done here? You know, it's a really simple way of breaking down what you can do. Okay, so what we did was we also got Paternity, which is another client of mine. I introduced 2 of them to design some of these are little 250ml bottles that they put just a cool pattern on working with Paternity, and they started selling those online because you can use those to take on planes. Okay, so all of a sudden he had a little direct consumer travel pot thing. He did Planet Organic, organic shop in London. They came to him saying, could you do all our refill bottles because you get this? So he did that because of course he could print them as well as supply, because effectively he had these bottles in stock. And then he also, because they did short runs of things, he then also launched this little personalized pot business that you could he built a completely different website because they had this personalization capability within the business. So do that for your business. If you want to unpack your knowledge, put the knowledge in the left-hand column. Work from left to right, or if you're left-handed, work from right to left. But always start with the one that you want to unpack in the left-hand column. So, you know, you might decide that you want to unpack, see what opportunities there are in your clients and customers. So put them over there. You know, if I was doing clients and customers, I'd start, you know, creative sector, cultural sector, who's in that? Tech sector, who's in that? You know, it's really interesting to unpack what you know. Okay, break time. Okay, does that make sense to people? Yeah? Have you ever thought about your creative businesses or your practice in that way? Great, good. And what are you doing? What have you come up with new things?
Still in the process.
Okay, so that is a really simple way of just pushing it and pushing it and pushing it, unpacking, because you own all of this stuff, okay? It's really important, and it works for any business. I mean, you could go out and offer this, you know, you don't need me here to do it. You could go out and offer it to your clients. What could we do with the stuff you already own? Let's do something new with it. Any questions before everyone's looking like they're hot and steamy and need a drink and a cup of tea and a blast of fresh air? Okay, any questions from that? Yes?
Yeah, I have a question about this being stuck in the ideation phase. So let's say you have this idea like the cake app, but you need some tools or help like designing the app or tech help, launching a website, designing a website, that sort of thing. So you're being held back by, let's say, investing in people, hiring people to do that, if you don't have the capital. how do you get past that?
Well, you can do a share model. You can say, okay, I'm going to put this on the table, you're going to put that on the table, and we'll come up with a contract between us, which, does that. I haven't had any money ever in any of my businesses, and I try and encourage all the creative businesses that I work with not to get off grants, to get off expecting anyone's going to invest in their business. So often what happens is the companies I work with, they'll have the day job, so they might do production services if they're a video or production company, and then they've got their IP development, and we transfer revenues across. Most of the companies I work with are tiny. Some of them have revenues in sort of under 100,000 or whatever. So we have to be really, really inventive, and we are. And they fly. The patent, the little patent company, the sweet company. They were 3 people. They couldn't afford a patent, so they had to think about how they could be really inventive about getting the money, and they would pay incrementally for each bit of the patent as they got a bit more money. And they worked hard. They ran events. They did all sorts of things to, they managed to get the sweets into a range of stores around London. They managed to get them into all sorts of places so that they were creating a revenue so they could pay a bit more for their patent. Because they didn't tell anybody the secret of how the recipe. They were available, but you couldn't. And they'd already done the initial filing, and if you do your initial filing, then that protects it. But that's what you do. You try and, I'll have a bit of this in order to do that, a bit of this. I paid for the self-publishing of my book, and I can tell you, I didn't have any income or any revenue. It's a full colour, big format, fuck off book, because I knew if I had got a publisher, partly no publisher, lots of publishers said they loved it. Great, because I had an agent, great. Who the hell was I? Nobody knew me, so they weren't going to take it on. And also, if a publishing company had taken my book, it wouldn't have been big format, it wouldn't have had photographs and full colour things in it, it wouldn't have been what I wanted to be, and I wasn't prepared for the audience that I wanted to attract to it. I was not prepared to compromise. So I realised I was going to have to foot the bill. So I think I did, that year, I think I did time and a half of work. I was not only doing the book and overseeing the book, but I was working all the normal working hours, and then I was working 50% more in order to cover it. But it was worth every single penny. And I remember delivering the manuscript when, in fact, we thought a publishing company was going to take it, delivering the manuscript and then going on holiday. And then I came back after a few months, discovered that no publishers wanted it, and then I had to go down the self-publishing route. And I think that was the closest I've been in my life to a nervous breakdown, because I work with an absolute horrible team of people in the self-publishing world who I thought were going to be really good, and I realised that actually if you've run a design business you probably know more about what sells to creative companies than if you run a publishing business. Anyway, there we go. Any other questions? Okay, well what we are going to deal with next, after we've had a break, because I think everybody needs some fresh air, is how you're going to harness what you find to think about growing, okay? Alrighty, so, and we'll talk about models, and there will be a couple of new diagrams that you can draw that are very easy. Okay, so what we're going to do now is we are going to slightly move on from some of the bits, and we're going to do some really different thinking, okay? And we're going to look at how you can harness your IP for growth. So, okay, I've just said that. Back to my old mantra. I hope that's been driven into your brain by now. Okay, so we've done this. Yes, you're familiar with that. You've got the diagram on that. You know exactly what's going on. You've done that diagram. Okay, now there are 5 opportunities for your intellectual property, okay? The first one we're going to think about is past and present clients. You know, when you did that amazing map of, you know, you identified all the skills that you'd ever been paid to do, and what you can do is repurpose those skills in interesting and different ways and go back and sell some of those things to your past and present clients. Because, or you can do, you know, Pod's, when we saw Pod had come up with all of those different revenue models, he went back to his past and present clients to sell them to. Andrew, the editor, came up with that course and went back to his past and present clients to sell that course to. Because your past and present clients love you. They've paid you. Do you want to come and sit around here and then you can see? They've paid you. They love you. They want to work with you. So why not think of new things that you could sell them? It's really, really key. This was him working with people that had already engaged with his business, who had paid him money, who were on his platform. So why wouldn't he think about things to sell them? You know, it is much easier to sell to your past and present clients, unless one or other of you has fucked the relationship up, but hey-ho, always happens. So really think about what's the opportunity with past and present clients. Think about what you can sell to future clients. Do you remember I mentioned this morning that was the clause in the contract that M&C Saatchi had added that was about if they came up with something new and inventive for their client that was outside of the brief, they reserved the right to present it in a meeting, and if the client liked it, they would come to a commercial view about it. You can't do that with your past and present clients because you've already got contracts in place with them, but you can do that with future clients. Okay, you can charge future clients in different ways. So maybe you charge your past and present clients on a service model, a day-by-day model, but your future clients, you can charge on an output. So instead of, I'm going to charge you on a day rate and it's going to come out at £7,415, I'm going to charge you for an output at 12 grand. Because that's the value of my experience. That's the value of what you're going to get, and if I over-deliver, that's my business, but that's what the output of what the value of what I do is. And it's much less easy for them to beat you down at price. You're going to get this, and this is the deal, okay? So future clients, you can have completely different relationships with. You can determine the terms. The other thing that's really important about future clients, often with your past and present clients, when you work with them and you sit down with at the table, they are in the parent relationship, and somehow in the creative sector, you seem to get pushed into the child relationship. Okay, I don't know how it happens, but it keeps on happening. When you're working with future clients, remember, they are buying skills, talent, ability they don't have, okay? So make sure you are seen as collaborators, as partners at the table of equal value. Okay, it's really, really important you get yourself out of that parent-child mentality. There is a client who I have worked with on here, and I'm not going to name names or on the presentation you've seen today, who really, really was a chairman of a company who really, when I was working with them, kept on trying to push me into that child relationship, and I absolutely refused to go. 15 minutes into the meeting, where I was being asked to help them do all sorts of things with IP, I wanted to finish the meeting. I wanted to finish the Zoom call because I was so furious about how I was being treated by this person who felt he could be rude to me because he had the money. I finished 2 hours meeting. I closed down the Zoom. He left the meeting after about 30 minutes. I closed down the meeting, I went out, and I had never done this before. I poured myself the biggest glass of gin, and I just threw it back, and I texted my children just this mass of expletives. I was so angry, but I'd absolutely refused to be pushed in. And the next day, the person who was my client 24 hours later, sent me an email to apologise and to pass on the chairman's apologies. 24 hours later, I was fucking furious. Be the expert. Okay, so future clients. Again, when we saw Donna Wilson, this is how she was selling to future clients, okay? She couldn't do it that way to past clients. Future clients she can. Okay, what can you sell to your competitors? Nobody ever thinks about competitors being of value, but there's lots of things. If you find something that benefits a big industry, you can sell it to your competitors. If you solve a bottleneck in a business, you can sell it to your competitors. Stornoway, the people who got a patent way back this morning, if anybody can remember that slide, Stornoway are developing a product that they sell to other creative companies. He's in the tech business, but he's selling it to other tech and creative businesses. So really think about, Taxode, okay, this app that I've showed several times. This was a graphic designer and animator who always was worried that he didn't have enough tax set aside to pay his tax bill. So he came up with this and sold it to other creative freelancers. Okay? And it's really intuitive. As you pop in your income, so this person's earned 23,500. So you pop in your income, and as your income goes up when you invoice, the expenses that you put in, it tells you what your profit is and how much tax you need to have aside today to cover your tax bill if you were sent your tax bill today. Well, he was selling it to all the other freelancers he knew. Then there's an opportunity for new buyers. Okay, so what do new buyers, how do I define new buyers? I define new buyers as people that have suddenly come into my sort of radar landscape, that maybe have got new money, that are trying to do something, are trying to get into this area, that I could help in ways that perhaps I haven't anticipated. So, for example, perhaps some venture capital money has come into the market. They've invested in a company, they're looking to grow the company, there's suddenly new money. They may not know much about the marketplace, so you could go and work with them and do something, sort of really quite different with them. And, I skipped a thing. Oh yeah, sorry, this is next. Okay, so this is a tiny little film production company I work with. This is a really good example of how to repurpose new thinking and to access money in the marketplace they hadn't done before. So Irene's Ghost was a sort of documentary film that Liz, and can't remember her husband, his name, Neil. It was a film they made about his mother and the slow dementia that she had, and following postnatal depression and things like that, okay? And so they were a creative company, it won lots of awards, but while they were making the film, in their past contacts, they realised there was an awful lot of behavioural science they were learning about in here. And as the more they discussed about what was going on and the behavioural scientists contributed to the film, the more they became completely intrigued by behavioural science. And one of the things that the behavioural science said was, behavioural science is really interesting because when you can resolve a huge amount of behavioural science issues using VR. And they went, oh, this is really interesting because we're really interested in VR. Anyway, cut a long story short, Liz from / launched a VR production company called 360 Safe, because what they do is they do VR training programs completely based on the behavioural science they got out of these behavioural scientists at the university, and they do behavioural science. They do VR safety programs for construction companies. They've managed to reduce in their clients the accidents on construction sites by 49%. And we're not talking about 49% for a small company. These are the biggest construction companies in the UK. That's the impact that VR can have that they discovered here. So this was an asset that they took forward, completely new money to the marketplace for what they were doing. And what's lovely is they do all this and it funds all this. So really, really think about how you can, find new money. And then there's new audiences. Okay, so I define new audiences by what can you sell the person walking past in the street now? What could you go out and go, oh, I've got something to sell you? What's in your business that you could go out and do that? Is there anything? If not, create something. Could be a talk, could be a course, could be an app, could be a pair of ballet shoes. Think about what you can do as a D2C business. Because, you've got the market. You can do it through social media. You can do it so many different ways. Okay. Repackaged expertise. Oliver Heath, leading biophilic interior designer who I worked with for several years, advises architects, governments, all sorts of things on biophilic design globally. So he realized that he'd written books, he's been on TV, but actually he wanted to devise an online learning school. So he set up a design school in Thinkific, learn how to implement biophilic design in the home. Revenues while you sleep. Okay, profiting from new IP and the rights this generates. Whilst there is no shortage of ideas in creative companies, you need to think about your ideas differently. Okay? So, I got really, really fed up when I was working with all my clients at how incredibly self-limiting they were in their business. I spend my whole time where people go, oh, we're in an accelerator and you've only got to think about one idea and you've just got to focus on your idea and go for that. Acts know-how. Or you could put, working someone like here, you could put CNC modeling at the basic idea. How could you do more things with CNC modeling? So let's just go back to green life. Okay, what I want you to do, oh, hang on, we've got another slide. Okay, now, if I was a web developer or an app developer, I'd go, I've got this idea for a web app that's about green living, okay? What have you done by saying, I've got a web app that is about green living? You have effectively completely cut off anything that you could do with your green life thinking in this area, and in this area. Because all you've done is come up with one idea for a web app. And if that doesn't work, you're fucked. So cut out the default. Do not default to what you know. You are way more creative than one discipline. Okay, we've really, really seen that. You've really seen that because remember you did the skills, remember that you did all the clients, remember that you did your background, you're using all of that. Remember that you have all sorts of different interesting and exciting contacts in your network, okay? So, get rid of the default. A web app could be one thing, but then what you do, you've got your green life, start filling in all the different things that you could do in this space with that theme. Don't self-limit. So, green life, and this is where your music thing comes back. Green life, okay, you could do some poetry and rap online. You could do children's lullabies. God, has anybody written a green musical? Music albums. We could do toys. We could do teaching packs. We could do garden seeds. We could do a mobile film. We could do a TV series. We could do something really fun on TikTok around green life. We could do a VR concert. Okay, just keep pushing it out there. Now, you only do web apps. That doesn't mean that the idea that you had here doesn't have value in other spaces. You may not know how to create an audio storybook, but you know someone who does. What this gives you, if you really explode across the creativity and you do not self-limit, is myriad more opportunities, the potential for a huge amount of copyright that you don't even know about now, and potential rights to earn revenues in ways you haven't even thought about. So you could do a version of all of this for adults. You could do a version for children. Or you could go back through your different audiences. You could do a version for all your clients. You could do a version for, I don't know, any audience you chose. Okay, what you are doing is you're taking that core knowledge that you've researched around green life and going, I could do all of these things. Now, there is a danger in that. Everybody points out to me that you don't focus on one thing. No, it's a good job you don't focus on one thing, because sometimes that one thing doesn't happen. But what's fascinating about these things is a podcast does not cost much to produce and put out. But guess what? It builds you an audience. Instagram stories. You can do some quite easy things around green life. Doesn't cost much. But it builds you an audience and a community. YouTube channel would cost a bit more, but we know, we have a documentary maker in the room. What can you do with them? I've got a client who won a BAFTA for taking stories off her mobile phone and creating a film with, in fact, her dating history on her phone. So there are so many different ways today that you can build those direct audiences, and then when you've built the direct audience and the community, that has value for all the other things you want to do. Okay, so what you're effectively doing is doing this so that then when you launch the musical, Think and Makerspace, the musical, you've got the audience to market it to. Now, some of the, yes, I realise this is pushing it, but if you think about green life, there's already a Green Life Festival. What could you do around a VR concert? There could be a great dance performance about this, communicating in all sorts of different ways. And then some build audiences, some generate revenues. You could do audio stories, a YouTube channel, own content platform. There is so many different things. And if you do this around that underpinning idea, these things are not going to happen in 1 year, 2 years. Actually, they're going to happen over a 10-year period, maybe a 15-year. So your idea doesn't have to be one web app. It can be all sorts of different riches, because you're going to have done the research, you're going to find other people you want to collaborate with, you're going to do all sorts of things. This is a 10, 12, 15-year model. Treat it like that. Love it, nurture it. Myriad more opportunities, potential copyright, potential rights, even though most of these are not your default creativity and you will have no experience of many. It's really important that you don't self-limit. You absolutely go for it. Think about what you can do hyperlocally. Hyperlocal is a brilliant market. If you can do something at a hyperlocal level, there are millions of hyperlocals all around the world. Think about what you could sell at a hyperlocal to you, and then think about, can you amplify this and sell it online to all sorts of other hyperlocal audiences? Can you do the same thing regionally? Can you do the same thing at a national level? Can you do the same thing internationally? So, an audience community can be built online, locally, collaboratively, or all of them. You are the creators here. There is no limit to your creativity. Absolutely no limit at all, except the limit that you put on it. And each potential output that you add could generate new IP, new additional rights, more revenues. So, for example, let's just take a book. Green Life, okay, you've decided that you're going to launch a children's poetry book. There was Phyllis this morning doing her poem about doing her poems about trees. Okay, you could publish a book. So if you published a book of your poetry or of your graphic designs or whatever else you do. Or maybe you've come up with a character when you're at university, you decide you want to launch a zine. Okay, your rights include publishing, copying, reproduction, adapting, renting. You can earn revenues from all of these. Lending, there are broadcast rights, public performance rights. The rights go on. If you just did a web app, you wouldn't be able to access all of these rights. Okay? I got a check from the Authors Licensing and Collection Society for my book 2 days before I came out here. It wasn't a huge big check, but it was revenue I hadn't expected. You know, the digital version of my book is available over in the US. £5.32 came in yesterday morning. Okay, it's not a lot of money, but I didn't do anything to earn £5.32 in the last few weeks. That was money that just came in. Think about a song. Okay, a song's got a whole lot of different rights. Okay, so, and again, you will know this, there are rights for the composition and there's the rights for the sound, okay? So the person who owns revenues from the composition, which is the melody, chords and lyric, of a songwriter, the lyricist and the composer, and they will own the music publishing rights, the mechanical rights, the synchronization rights, the sheet music, the performance rights. That's that side. And then this side, for the actual sound, so the recording, the performing artist, the musicians and the label will own those rights and earn revenues. And that will include a master use license, it'll include distribution rights, such as streaming and performance rights. Okay? Yeah? So there's a ton of money. Now, let's just say, Green Life, okay, we came up with an amazing, amazing, fun green track that, you know, with a chant. And we got somebody great to write some music for it. And because they'd contributed, we agreed that we were going to come to a deal on all the revenue share out of it. Okay, so you could have a song, so you could have a recording, but also you could potentially, because you're an animator, develop a wonderful little animated series. And the song is repeated in that animated series. That animated series gets picked up by the BBC, and it gets picked up and is distributed around the world. Because you've registered your music publishing rights over this, and also because your nephew, aged 8, performed this, all of a sudden, every time that animation plays with its opening music, you get money. Every single time. Now, you may not be in this world, but you may be, oh no, we've gone the wrong way. No, hang on, let me just go back 2 slides. Oh no, rather more slides. Okay, you know, you may be able to do some of this around this thing. Okay, so really, really don't get limited into just the web app, because there's so much more opportunity for creative geniuses like you in this space. Nobody will believe in your talent more than I do. Okay? When I work with clients, the reason I hear their background, the reason I ask them to tell me their life story is because I will have total faith in who they are as people. Nobody will have as much faith as I have in their creativity, as I have in their creativity. Okay? Not their parents or anybody, because I've understood what have been the building blocks to it. That's why it's so important for you to really, really think about what your assets are and things like that, because that is the building blocks for all of this. Right, let's just scoot forward to where we were. Okay, this model, intelligent creativity, can create a 10-year plus IP rights and revenue plan for you. You don't have to do it all at once. ABBA didn't. So, you know, really think about this. You can do so many things, and it doesn't all have to be on the same theme. You know, poetry and rap isn't going to appeal to the same audience as children's lullabies, necessarily. It could do, but, you know, hey-ho. What toys can you do? What teaching packs? You know, these things can just go on for miles. They really can. And that's what's so much fun about them, is suddenly you go, oh, somebody has just walked into my life and they do this. Oh, amazing. We could do, I don't know, we could do a film, you know, a mobile film with them. So, but what's really important, and I hope you've learnt from this morning, is that you do that grid, but you need to turn these concepts, these ideas, into something. So even if it's just a written piece of paper, because as we know from this morning, each something is protected by copyright law and has a range of rights attached. Each something may also have a different audience that you can build. And audiences are valuable, unless you either choose to give those rights away, sell or license them, or it's owned by somebody else in a contract you've agreed to. We've discussed all these things, so I'm not going to go into them. Okay, this is one tiny, tiny business that when I started working with Vicky, she was literally just a ballet bar-based studio. She could only take 11 people in her studio at once, and she went, oh, I need to find some additional revenue. Within, I suppose, about 3-4 months, she uses the Lottie Burke method, which was, Lottie Burke was an American dancer. She used the Lottie Burke method, but she had developed it way, way beyond anything Lottie Burke did. Anyway, within 4 months, we'd set up an instructor training program. She worked with, you know, just people who lived in her local area that came into a studio. Suddenly, after about, she'd been running this, I think she'd been running it for about a year. Every 3 months she'd do an instructor training program for 2 days. She'd charge 650 quid for the 2 days. Suddenly people were flying in from Canada, from Israel, from everywhere to do her instructor training program because it was so good. We then realised that she knew lots of the bar training people around London, so she set up a bar summit. There's lots of yoga events, Pilates events, but there wasn't one for bar. So she set that up. She and I, you may have noticed on one of my trademarks, I've got the business of fitness because she wanted me to set up something with her around looking at the business side of the fitness industry. And she also developed something called the Bar Collective, which is a whole network of bar suppliers, bar people and things like that. So suddenly she had gone from one revenue stream with a few products to 1, 2, 3, 4, 5 revenue streams. Okay? And, you know, there was a methodology, a process, and a network. Okay, so really, really think about that. She then got hyperfit, and Channel 4 in the BBC, in the UK ran the year that women were allowed to join the SAS in the UK. Channel 4 runs a programme which is called SAS Who Dares Wins, where they put, I don't know whether anyone's familiar with it, where they send lots of sort of fit people out to crazy environments and put them through a whole load of programmes. They take 20 people and they get down to one winner by putting them through the SAS training programme. Vicky got very fit. She did it. She got down to the last 4. She then decided she was going to take another challenge on because it was a good way of marketing her business, and rode the Pacific. Okay, and they broke the record, her and 2 other women. She then did an ice challenge, and I don't know what her next challenge is. So now she goes and speaks on resilience. She's a TEDx speaker, as well as earning her revenues. Okay, so this is another client of mine, Plug-in Media. They have a brand called T & Mo, which is a little animated brand. It is all their own intellectual property. They developed it because they wanted their own IP, and this is what their model looks like now. Okay, they're earning in all sorts of different ways. They are tiny, really tiny, and it's taken them a long while to do this, but they're doing it. This is, okay, here are two people I haven't worked with, two slides with people I haven't worked with. Okay, Taskmaster. Again, really interesting. Is anybody familiar with Taskmaster? Okay, Taskmaster is a comedy series. So it was started by Alex Horne, okay, who is a comedian, who launched it at the Edinburgh Festival. And basically the whole premise is that you get 5 comedians and he sets them ridiculous tasks, okay, and then Greg Davis and he then judge who won this ridiculous task, okay? So it was done as a performance. Then it was done as, it was bought by Dave, one of the streaming channels in the UK. And then Channel 4 bought it, okay? So we've got a format going on here that Channel 4 then built. So by this stage, they were on about the 13th series. And they were approached by US distributors or by distribution company who wanted to operate, who operates in the US, and they said a US company is really interested in buying the whole series to distribute across the US, so they got revenues from that, and they said that the US also wanted to buy the format, and I don't know which channel bought the format. Anyway, they made a US version. It was pulled after the first episode. It completely tanked. And, you know, the channel had wasted, in the US, had wasted a lot of money on it. The other thing that happened was that the channel that had bought the distribution rights was not getting the audiences they thought for it. This has been incredibly popular in the UK. However, Alex Horne had put some stuff up on YouTube, and he noticed that a massive audience was watching was watching their YouTube channel from the US. So he knew he had a US audience, but he just knew it wasn't in any particular, for any particular channel. And by this time, Taskmaster had been sold, format rights had been sold to Japan, all sorts of things, and they had the 13 version. So what he did was he decided to launch a Taskmaster own channel on YouTube, but a really big proper one. Sorry, their own channel, not on YouTube, with a $5.99 subscription, okay? And he said it was a total gamble, but they populated it with outtakes from the shoots. They put the Japanese thing on it. They did all sorts of crazy stuff to put material, because he runs a production company. And it's absolutely gone, you know, sort of vertical with revenues coming in. You know, they're earning $5.99 a month subscription from all over the world. You know, he wakes up every morning and he says, there's yet more money in my bank account. So, you know, you don't have to always think about selling it to somebody else to push it. You can do it. And then, again, I'm afraid this person hasn't been one of my clients either. But again, I think a really interesting use of IP. So Dolly Parton and James Patterson, award-winning author, wrote this book, Run, Rose, Run. And what she did throughout this book was, guess what? It's a story about a country and western singer from the wrong side of the tracks who becomes successful. Oh, where have we heard that story before? And what she did was she used the story to effectively write lyrics for songs. People had read the book, they'd read the lyrics as part of the plot. So guess what she does? She launches it, all the lyrics and songs on a CD and, you know, on an album. I just thought when I read that, that's such a smart way of playing it. I just really like that, so I'm going to include it. Okay, so creativity drives value. Okay, you can do that diagram anytime you want. You can do it with any people, and I absolutely promise you, it will show you more value in your ideas than anything else you do. Now, I'm going to draw one diagram. Oh, let's just pop this here. I'm going to draw one diagram up here because I want to show you how the revenue models can work for this. Okay, so 3 circles. Can everybody see, sorry, 4 circles. Can everybody see that? And sorry if you can't. Okay, 4 circles. This inner one is this year, 23, 24, 25, 26. Let's use green thinking, okay? We're going to draw a line that cuts all these circles through, and this is going to be turnover. And this is going to be our green thinking business. Okay, this year our green thinking is probably going to only earn us about 10k worth of revenues, because we're going to be able to do speaking and maybe some development, some things we might be paid for. We might get some university lectures and things like that. And then you come out here and say, well, what would I like my revenues to be in 2026 out of my green thinking project? Okay, I'd like them to be 250k. So what you've got to do is work out what the revenue is here, going to be here and here to get you to there. From 10k to this is probably going to be a tough call. So you're going to probably aim for about 75k. You're going to start to set rabbits off here. We'll talk about the rabbits in a minute. And you're going to say, okay, this jump is lots of hard work, but not much revenue. Then all the revenues begin to escalate because, so I would say here they're going to be about 165, okay, and then they're 250, okay? Now, okay, what we've got is several other lines. We're going to unpack these revenues and think about what sort of revenues we can develop. So let's say the main revenue around green thinking, the first revenue we came from was talking, education, knowledge, okay? Because that's what I've had to use to do my green thinking things. So you put a revenue here, we know it's 10k there, and then you go, okay, the following year it might be 15k, the following year it might be 30k, and that's probably going to stay about that. Okay, now we're going to have, let's think about, we're going to develop TV. We want to have TV screen ideas. Okay, so because we've done lots of research here and lots of talking, we're going to think about that we might begin to earn revenue from some screen ideas that we had there about here. So let's say we maybe have about somewhere in the region of 50k, because we've managed to get a couple of, maybe a commission away or something like that with a broadcaster. So what you're trying to do is to build, this becomes your financial plan, okay? And then here we can start maybe earning distribution revenues for some of this, because we've got a program or something that we can distribute. So what you're trying to do is, I'm explaining this too quickly, but what you're trying to do is build yourself revenue models that can operate over 3-5 years. But what you're trying to do is constantly think about how the money and the knowledge and everything that you have can drive revenues out in these different circles. And what's fascinating about this diagram is it's not an Excel spreadsheet. You can use this as an affirmation up on the wall, and you can say, okay, from my green thinking business, I may be going to earn 10k this year from it, but I know I'm heading for I want to head for 250k in 3 years' time. And so you start planning for this even when you're here. And that's what that diagram, the IC diagram, does for you. And there's something magic that happens, and whoever talks about magic in business meetings? Not many people I know. But there is something amazing about those diagrams and that diagram. I haven't had a single company who I've done that diagram with who hasn't got to those numbers. There was one company who wanted to go from, I think when I started working with them, they were probably about 850,000. And it's a company that you've seen there. I put 3 years out, they should be on 5 million. They rang me the week before the end of their financial year, 3 years out, and Phil went, Erica, guess what? We're at 4 million, 995,000. And I went, when's the end of your financial year? And he said, oh, Friday. It was Tuesday. And I went, you've got 3 days to get there. Don't prove me wrong. And he went, even if I have to pay it in the company myself, I'll do it. So it is amazing how effectively this is. There's another company that you haven't seen on here, or I think there was a logo, who, when I started working with them, was 800,000. We did a really, really careful plot of this, and they are still in this second year. Well, they sort of overlapped there. They've got 12.5 million out here. Huge, huge growth from 800K to 12.5 million. They are on track. And it's because we devised their intellectual property, we devised the IC model, we worked out where we could plot the things that would generate revenue into these maps. We did a huge, great calendar as to what they needed to be doing each quarter. So it's not just it happens, there's a lot of planning, but the tools that you've had ever so quickly today can get you this growth across all those different aspects. And, you know, the 12.5 million, you know, they're doing TV, they're doing film, they're doing unscripted, they're doing scripted, they've got podcasts running, they've started doing some VR. So, you know, they're talking to people and working with people they'd have never thought of working with before, because they want to achieve the success with their assets that they can see. Okay? Any questions? Oh, silence. Okay, so this sort of model, and most of the things that we've talked through, okay, are in my book. If you want a digital copy, if you go through to my website, if you put in sale 33, it's from £15 down to £10 or whatever. So just put that in if you want a copy. This intelligent creativity stuff was published after the book. So that's on my website too, and it's just a digital version. But yeah, so, you know, these things really, really, you've got to push them. You're the ones with the creativity. So you need to really, really push. Okay?
I'm sure that this has already been said, but why, you know, we can look at it again. It does need to be original. So the bar is quite low, but it does need to be original. And there needs to be some sort of fixation. So just an idea can't be protected. You do need to have it written down, or, you know, a photograph must exist. There needs to be something to call a work. The duration is normally the life of the author plus 70 years. There are exceptions, like the database right is 15 years, for instance. And it's always helpful in works in which you're invoking your copyright to use a copyright notice. So the little C in a circle, the year created, the author, a full stop, and all rights reserved. You'll see in my copyright notice that I have 2019 to 2023, the name of my employer, and all rights reserved. And the reason that you see 2019 is because I had a version of this presentation back in 2019. And I'm putting people on notice that this was created in 2019, that changes have taken place throughout the years, and up until today. Okay, so 2023. That's usually used on websites, for instance, where a website can be quite old, but is being constantly renewed. Patents, I don't know how useful patents are for the type of work you do. Just as a brief overview, again, we're fully harmonized with EU and the European Patent Convention law. This protects inventions, so a new medicine, a new gearbox, a new sort of hinge for your door. All of these things are potentially protected by patents. It's very, very important that if you come up with a new idea and you don't know how you're going to be protecting it or whether you need to register it for protection and so on, don't disclose it to anyone, okay? Don't disclose it before you obtain advice as to its protectability under the law. Non-disclosure agreements are your best friend. It's always a good idea to ensure that any disclosures that have to happen take place under a non-disclosure agreement. You should always seek expert advice. That might be a lawyer, that might be a patent attorney, that might be an expert in IP on how to obtain it. You should never try to draft the patent yourselves. And patents are territorial, so they are valid in the country in which you register them. A Cypriot patent, for instance, a European patent, and sometimes there's an international avenue which you can use. In Cyprus, we have very few national patents, mainly because it's so expensive to get one. If anyone is interested in applying for a patent, there's a discount going on now, and the search fee, which is a necessary fee that you need to pay, has been reduced from 2,400 euros to 480, which is, nice. They last for 20 years and they need to be renewed every year. Again, this can be expensive, but they're there, and it's always worth seeking advice as to whether you're entitled to a patent. Trademarks. So trademarks, again, are protected under the law. We've recently harmonized our legislation, so we're fully aligned with EU law again. You apply to the registrar of companies for protection of your trademark. Examples are your logo, a slogan, your signature. Some people, who give a lot of autographs want that protected as a trademark. It basically provides you with a right that you can take to court and prevent a third person from using something that looks like it. And it's often used by designer brands, for instance. It's used by food and drinks companies. It can be very, very helpful. You apply to the registrar of companies. They'll examine it. There are some absolute grounds based on which they will refuse to register your mark. Are you trying to ask? No? Or just, sorry, no worries. So absolute grounds include, for instance, if your mark looks like a flag, or if your mark, this is a good example, if your mark is what we call generic. So once upon a time, the Hoover brand, for instance, was actually a brand. Now everyone in Cyprus calls their vacuum cleaner a Hoover. So if you try to register something that is now generic and is used to describe all sorts of objects that belong to that group, for instance, they won't register it for you. Then we move on to something called relative grounds of non-registration, and that's if it looks like a previous mark, basically if it looks like a previous mark, or if it looks like a previous right, such as a geographical indication or something. You can apply to register your logo, for instance, on a national basis as a Cypriot trademark. You can apply to register it as an EU trademark, so it's valid all over the EU. And you can apply for what we call an international trademark. That does not mean that it's valid internationally. It just means that there is a procedure through which you can file once and choose certain countries that belong to this system. And the World Intellectual Property Organization will send it off to these national law offices. So it's a one-stop shop, essentially. But if you succeed in registering, it will only be valid, it will only be in force in those countries. So it's not really it's more of an international avenue rather than an international mark.
If you want to add other countries,
yes. Oh, yes. No, well, not necessarily. If you have an international mark, you can do what we call a subsequent designation and file one application and choose several more countries. Yeah, which is very helpful. Of course, if any of those countries have a problem based on these absolute grounds or relative grounds or whatever, you're going to need to hire lawyers or agents in those countries to overcome the objections, and that can get expensive. You can decide it on a case-by-case basis.
The related rights, what are they called in the UK? Is it neighbouring rights?
No. This is related rights are for copyright. Yeah. Some jurisdictions call them neighbouring rights.
And the moral rights in the UK, what are they?
And moral rights.
Okay.
Yeah, I mean the UK has always had a bit of I'm not licensed to practice in the UK, just to clarify. But academically speaking, the concept of moral rights has always had a bit of a tension in the UK because it's a concept that came from civil law countries. So France and Germany, where intellectual property is considered to be an extension of the author because of his intellectual sort of effort.
So it's like publishing rights in music, let's say?
Those are neighboring rights, not moral. Yeah, moral rights are very, very specific. Moral rights are, the right to paternity, so the right to insist that your name is linked to the work, and the right to object to offensive use of the work. It's very, very specific. And in Cyprus, it only lasts as long as the author is alive. You can't, so it's not technically valid.
70 years after.
No.
So only as long as you're alive.
Yeah, in Cyprus.
70 years after your death, you're still not allowed.
No, for moral rights.
For moral rights.
Yeah.
But for copyrights or trademarks or anything.
Copyright is valid. Copyright in general, not moral rights. Copyright in general is valid for 70 years after the death of the author, and trademarks can be renewed indefinitely.
This includes artists. So somebody cannot use my work, let's say, as an artist. If I die in 70 years after, they cannot use my work without a special permission?
Yes.
Make a bag or something.
Yeah, so it's, with artists, it always is a bit, like, with your right.
All right.
Yeah, no, as an artist, you have copyright in your work, okay? If you sell it, you will always need to be careful when you sell your right further on, or your work further on. What are you selling? Okay, are you only selling that specific painting? Are you assigning your rights? Normally, the way it works is you're just selling that work. You're not giving them the right to create handbags with your work on it, or t-shirts, or postcards, or so on. Yes, but my advice is to always be very clear with this, because the last thing you want is an expensive dispute on your hands.
Oh.
Yeah, and the other thing that artists have, for me, it's a must to have a contract.
Okay, do we do these contracts in Cyprus, or do we have to go somewhere else?
No, you can do it in Cyprus, it's not a problem. It depends who's drafting it, what law is applicable. But it doesn't need to be something complicated, it can just be a sheet of paper that
says
this
work cannot be used
for
commercial use and everything.
For instance, I can't provide legal advice here, but yeah, for instance. Yeah.
If you're selling pictures online, photographs,
Mm-hmm.
you have to specify that there are going to be more copies of it, or how many copies are there?
Yeah, with photographs, you need to be very careful because of how easy it is to copy paste things. And you need to use other means as well. You need to use watermarks. You need to use technological measures. You need to, you need to be proactive as well. Like as soon as you see your photo floating around, you need to be proactive and sort of report it, so as to avoid things getting out of control. Because I've got a train of thought here. With copyright as well, an artist has what's called the droit de suite. So that basically, if your work, your painting or your sculpture or whatever, is sold by a gallery further on, you're allowed to request a percentage of that sale.
Yes.
Yeah.
And if the guy who buys your sculpture
Mm-hmm.
wants to resell your work,
Mm-hmm.
they have to go through the gallery. And
that depends on the contract. That's a contractual thing. Yeah, and the droit de suite is limited to art market sort of professionals. So private sales are normally exempt, and also it's difficult to keep an eye on them, But when sales happen through art market professionals, this percentage kicks in, and most countries have what's called a collective management organization that you can sign up to, and they'll keep an eye on the art market for you and obtain the percentage on your behalf and pay it out to you at intervals, so 6 months, 12 months, or so on.
For how many years is the
This droit de suite, it's for the entire lifetime of the copyright, so plus 70 years. Yeah. Did someone have a question? Yeah.
I just want to say on the NFT space and in the space of the Polygon system, you can really control everything on the copyright and add anything and add in
You can both control it and it can also get out of control. NFTs are a really,
How helpful systems are technology working on protecting that?
Yes. Sorry, you've been very patient.
The CMO for neighboring rights in Cyprus for sound is it?
So in Cyprus we have about 5 CMOs currently. We have one's called PRS, and that's for music, and that's for lyricists and composers, mainly people with copyright. We have Gramo, which is for phonogram producers, which in Cyprus is copyright. We have CNR, which is for performers, so that's a neighboring right, that's the Cyprus neighboring rights CMO. And we have Dionysos Zagreas, which is for rights belonging to actors. Have I missed one? I think that's the 4 who are currently active.
For artists, where do we register, let's say, work?
Artists, well, we are in the process. We are hoping to register a CMO for visual artists.
It has been going on for so many years.
For a year now. Yeah.
For a year now, you're in the process.
Yeah, well, as an office, it's our pro bono initiative. We've been wanting to do that, but you know what the problem is? The problem is that in Cyprus, unfortunately, the legislation is incomplete. So we have a law, but we don't have the regulations in place to be able to register a CMO.
Why?
Because our parliament is late. Because there has been a copy deposited with some delay, okay? There is a copy of the regulations before parliament. It was tabled.
The one that is still under discussion?
Yes. Yes.
Is this the one that has been made like in the 1930s something?
No. This was in 2017. They enacted the legislation without the necessary regulations, unfortunately. And the regulations were finally tabled in 2022. They discussed them, they sent them back, and now they're still discussing them. So this is another problem with establishing CMOs in Cyprus, that we don't have the necessary legislative framework in order to register and then enforce the rights.
Because every time I've tried to even communicate with the Ministry of Commerce, there's nothing that can protect artists. There's nothing, unless it's only trademarks and some copyrights, but nothing else.
Yeah, there is
And patterns, a few, in like, as you said, we had a few, but as a European Union nation, can we register online through the European Union office, like through, I don't know?
For trademarks, yes, you can apply to.
For copyrights for art?
Copyright doesn't need registration. So
doesn't immediately.
Just have it when you make it. You have
it.
When you make it, you have it.
Yeah.
That's it. I don't have to put it somewhere officially.
No.
When it's unregistered, there is a limit of. That's what I've read.
No. Copyright does not, in Cyprus and in Europe in general, does not need registration in order to subsist. What does happen is some people like to use a digital repository, for instance, so that in the event of a dispute, they have a time-stamped certificate showing that, look, I came up with this work first, but it's not necessary. The US has a registration system, and it's the US Copyright Office, and you know. But in Cyprus, you do not need registration for copyright. So trademarks, yes. Did anyone have any other questions? No. So 10 years, 10-year in 10-year intervals, and you can renew it indefinitely. I think the oldest trademark in Cyprus is from like 1902, and it's those matches, you know, those, what are they? Yeah. So, okay, it doesn't like me. Oh yeah. Thank you. So industrial designs, sometimes this is also quite helpful for creative people. Industrial designs protect the shape of the product. Some are, for instance, the Coca-Cola bottle. Some industrial designs include snow globes. There's a special kind of snow globe now that was recently, it was recently involved in a dispute. If the shape of your product is new, novel, and has individual character, it can be protected. In Cyprus, you need to register it for protection. In some jurisdictions, you do have some protection for unregistered designs, but that's usually more limited. It's very quick to get an industrial design registered, something like 3 or 4 days, because they only check that you've completed the formality. So they only check your application, that your pictures look nice and so on. This, the novelty and individual character, is not assessed when you register it. And novelty and individual character will be assessed if you try to use your industrial design to stop someone else. So if you try and use it to stop someone else from reproducing, for instance, your lovely protected creation, they can say, oh, look, I don't think this design should ever have been registered because it lacks novelty or individual character. And the court will then have to assess that, and you'll have to see if your design will survive the attack.
Can I ask, can you do a novelty individual character check before you do your...
So you could do a search online. You could do. There are several tools at your disposal that you can use, but ultimately, you can't really predict it.
And it's only for Cyprus.
You can register it on a Cypriot level, so on a national level. There is an EU design, so it's called the Registered Community Design, the RCD. You can register it, and then international through the Hague Treaty. It's like the trademark, so it gives you an international avenue through which you can choose jurisdictions for protection. It's renewed every 5 years. It's quite cheap. It's quite helpful. We've had successful litigation with industrial designs before, but they're not very popular because people don't know it. Yeah. Trade secrets. So, trade secrets are and aren't IP, my PhD, which has been ongoing for a few years now. I'm trying valiantly to finish. Trade secrets are a type of IP sometimes. We have a new law in, it was enacted in 2020. Trade secrets essentially are information that by virtue of their secrecy provide value to your business. So something like the Coca-Cola recipe, for instance, something like the Listerine recipe, something like, WD-40, which is the hinge grease, yeah? That's also protected as a trade secret. And basically, you have protection for as long as it's kept secret. Now, for the law to provide protection to your trade secret, you need to show that you've taken steps to keep it secret. That you didn't, for instance, allow all of your employees to have a look at it whenever they wanted. That you had contractual obligations under your employment contract that, look, what we're about to disclose to you is to be kept secret, and so on. And this will only be assessed when you try to enforce your trade secret. Trade secret litigation usually arises when someone steals your secret, either through corporate espionage, which sounds very exciting, and I'm sure it happens, or if you have a disgruntled employee who goes on to sell your secrets to a competitor. And yeah, it's protected as long as it's kept secret, which is good because it means you can protect it indefinitely, but can get quite expensive because keeping a secret takes money, it turns out.
I'm sorry, so how do you lose the protection? Like, what do you mean until it's secret? If someone breaks an agreement, there is a secret. Does this mean that you don't have protection?
So it means that you can sue him in court, for instance, and try and obtain damages or even a court order preventing him for further disclosing the secret. But if that person shows, for instance, that information had been leaked beforehand, or there was a case where they had an issue with a server and he proved that their security settings on the server weren't actually that secure, the court will say, well, it's evidently not secret anymore if anyone could have access to it, so why should I give you a court order or damages? So that's what I mean by it's protected as long as it's kept secret. Because once it's out in the world, and obviously, it doesn't provide value anymore if anyone can have access to it. Domain names, I like my domain names, I'm not gonna lie. When you come up with a name for your product or your brand, it's always very important that you try and obtain the .com, for instance. And this is important in two respects. One, you have the domain name. And two, if it's taken, and in fact, if it's in use, you can see that it's probably not a good idea to go looking for trouble. So So you can have them on an international level, so .com for instance, or you can have it on a national level, .com.cy. In Cyprus, .com.cy, .org.cy, all of these are handled by the University of Cyprus, which is our national registrar, that's what they're called.
Handled by?
The University of Cyprus, who do not sell you the domain name, they give you a license to use the domain name. I mean, it's a small difference, but an important one.
What's the difference?
So they don't sell you the domain. You don't own the domain name. You are given a license, permission to use this domain name as long as you renew it and so on. And
Possibilities to own the domain name?
not in Cyprus.
Not in Cyprus.
Not for .com.cy, .org.cy.
.com we do own.
For .com, yeah. I mean, it depends on the registrar whom you're using. You need to renew it. And domain name disputes, so if you have an argument with someone, are usually, not always, but usually resolved through mechanisms that are set up by the registrar themselves. So you file a complaint, for instance, and then they'll listen to you, and then they'll ask the other side for their opinion. And you need to look up the Nissan dispute if you haven't already. There's a chap in Japan, I think, who has Nissan.com, and it's hilarious. Yeah, because he's not the car manufacturer. Nice. Yeah, it's very, very, I mean, you got to admire his tenacity, I'm not going to lie. Business names in Cyprus, they are, I don't know how many of you are Greek speaking, but they are what's called emborikes eponymίες. Emborikes eponymίες are not the same thing as emborika sήματα, which are trademarks, and which we, have already looked at. Business names are essentially a name under which you are trading that is not your own, and you are obliged to register them. So if you, for instance, have a company called, I don't know, Kokos Andreu Limited, okay, and you offer plumbing services under something called, Quick and Easy Plumbing. I don't know, that probably wouldn't be registered, but this is an example. You should register that as a business name. Like if you've got it on your card, if you say, oh, hi, I'm Quick and Easy Plumbing, you need to register. It's not a classic form of IP, but it is a form of protection in the sense that they won't register another company with a name that's similar to your business name. And in the event that someone starts using something that's similar, you could potentially, and this is a very big potentially, invoke what's called passing off, αθέμητος ανταγωνισμός, in order to go after them. It's not like an orthodox way of going about it, okay? But it does give you something.
Can I ask something? So let's say I have a trade name for creative studio. And is it different from, like, let's say there's a coffee shop that has the same name, or can they both exist at the same time?
Yeah, so the registrar, when the officer who looks at your application sort of examines it, they'll say, what kind of activities will you be conducting under this? And if they're similar to someone else, so, okay, those two, not so similar. But if they are similar, he'll say, look, you need to either get the other guy's permission for me to register it, or you need to stick something on this, like initials or something else, to make it different, or to differentiate it enough.
Just to mention our example, when we opened the company of the art studio, actually we decided to name it the Art Hub. We just needed that name. When we went to the register companies, they wouldn't accept it because it wasn't specific to them as to what we were doing, naming the Art Hub. So we had to change our name and say the Art Hub Visual Arts Laboratory. So we had to add all that, Cypriot, at the end, just to make sure that we got it.
Yeah, but there can be a coffee shop that is called the Art Hub.
It would be the Art Hub, coffees and beverages. So that would determine the cost of the company. But a friend of mine had also, parallel to me, after me, he had CY Art Hub on Instagram, where he used it as a name for a collective of artists. Now, because I registered my company and I have the business trade name, he cannot go to the register of companies and register it as something similar.
As a company, because trademarks are different. Yeah. Trademarks are a different register.
The business trade name and the company, they have to be together. You cannot have a company without a trade name.
This is different. The company name is different from your company name is your name. The business name is another name under which you're trading.
We did register for a trade name.
Okay. They can exist in parallel, of course, but they're not the same thing. The company name and a business name are two different things.
Okay.
Yeah.
I thought you had to add also because we did register via Borgina Bonimian, and then we also did the company.
I think you must have done an αίτηση ονόματος, so an application for a name, and then if that's approved, you can go on to register your company with that name. A business.
You don't necessarily need both.
You don't necessarily need them.
You can have a trade name, but you can work as a freelancer instead of.
Yes, so your trade name can be on your name as an individual.
Yeah. Okay, but to have a company though, you have to. We registered.
Yes, you must have a company name, but you don't necessarily need to have a trade name.
You don't necessarily need.
It's two separate things. Your company has to have a name, just like I don't know your name. Sorry.
Ioanna.
Okay, so you're called Ioanna. Next thing, you need to have a name. You need to go around the world with a name. Okay, it needs to be on your birth certificate. It needs to be on your ID card. Same for a company. They need to have something on their company. A trade name is a name that's not Ioanna, but something that you work under as well. So creativity studio, for instance. You don't need to have creativity. You might just work as Ioanna. And if you just work as Ioanna, you just have your name, i.e. the company name, for instance, and work. But if you work under a name that's not Ioanna, you also need a business name. And it'll be...
of course, that's...
Can I ask something?
Yes, always.
So, what happens if you discover that there's someone else?
I'm so glad you asked. I'm so glad you asked.
Same name, but like in a different country, for example.
A different country?
A different EU country, because that happened to me.
Yeah, so the business name is territorial. It's only in Cyprus. In fact, foreign companies can't register a business name, as I discovered fairly recently. If you discover that someone else is using a similar name, it all depends on what steps you've taken to protect it. So if you don't have a trademark, or a trademark usually, what are you going to do? And if you don't have a presence in that country, you can't even claim something like passing off. Ultimately you need to have some sort of right that you can use to base an action, an attack on. So if you don't have anything in those countries, then the answer is, I'm afraid, not much.
Yeah. Okay, so there is it's territorial.
Yeah. But even with trade names, actually, a client of mine once discovered that someone had a very, very similar trade name to theirs. And I went to the registrar and I said to them, look, this and this is happening. Can you please take measures to stop the other guy from using it, or I don't know, make them change it? Like, no, it's not my business. They said your client should sue them. And I was like, but you said that. Yes. And big companies are serious about protecting them. They will take you to court. They will, and we'll see some things later.
My idea for upfront Cyprus.
I don't think that's a good idea. No. Geographical indications, it's protected in Cyprus. Halloumi, Kalamata, olive oil, in general, when something is associated with a specific region, plus some other requirements. I don't think this is of particular interest to you. If it is, please let us know, and we would be very excited to help. It's not enough to create IP. Obviously, Erica and Leah have gone through this in a lot more detail. You need to register it where applicable. You need to protect it. Merchandising. A tax plan for profits. So some IP rights benefit from some IP rights have beneficial treatment under the tax law. Software, for instance, or patents. It's usually royalties. So to speak with your accountant, trademarks aren't applicable, or copyright. Copyright only in terms of software. So it's something to keep in mind. Who's the author? Again, if you work with other people, it's very, very important to always ensure that copyright belongs, not just copyright, IP rights in general, belong to the proper person. So if you're outsourcing the creation of your logo to someone, make sure that it's clear that the rights to that logo belong to you. If you have employees It's very important that you have a clause in the employment contract saying that IP rights belong to the employer. For those two, for commissioned works and for contracts of service, there are provisions in the copyright law that will protect you to an extent. But as we've seen, IP is not just copyright. There are many rights. And the last thing you want is a dispute over copyrights. I mean, we have this quite often, unfortunately, where someone creates something and they say, yeah, but I only give you a license to use it. I didn't give you the rights. And then, so anyway, make sure that your contracts are clear. You must ensure that you protect ownership afterwards. And yeah, we've already discussed non-disclosure agreements. Who are your best friends? After you've registered your copyright, or after you...
Could you tell us a little bit more about non-disclosure agreements?
Yeah, so non-disclosure agreements in general are used when you have an idea and you want to discuss it with potential investors or, funding entities, and you say to them, look, I'm happy to discuss this idea, but can you please sign this non-disclosure agreement? And the implication is, I don't want you stealing my idea and making a profit off it, yeah. So a non-disclosure agreement, just to be clear, is not like, it's not ironclad, but it does give you a contractual basis on which you can go after someone if you find out that they've disclosed their idea or used it or merchandised it.
So can you use it when you do a pitch?
Yes, you should be using it when you pitch. You should be using it. I mean, NDAs...
So it's not a contract?
It is a contract.
I mean...
No, it is a contract. It is a contract, yeah. Okay. Yeah, because both sides agree and it is a contract. You should get a lawyer to look it over just to ensure that the requirements under the contracts law are sort of fulfilled, because there are some requirements. So you need to have something called consideration. You need to have, but it is definitely a contract. And it's important to have it because if there is any IP in your pitch that, for instance, benefits from being secret, perhaps a patent, perhaps a trade secret, it would be a shame for you not to protect that from the outset. Yes, he was first, I think, and then you.
Can you do an NDA to protect an idea, like the presentation of an idea?
Yeah, a lot of people do, because ideas per se are not protected.
Correct.
Yeah.
Can you do an NDA to protect an idea?
You'll say, I'm disclosing this confidential information in return for something. There needs to be consideration. Speak with your lawyer about that. But I'm protecting it, and then I'm just disclosing information. Please keep it confidential. I mean, you don't need to have something registered or something, you don't need to have an actual IP right. The information can be the subject of your contract.
Yeah, no, but it's quite risky because ideas are quite broad. So somebody can pitch an idea, which is very similar to an idea that somebody else pitched.
Yeah, I agree with you.
Then how do you kind of differentiate?
Yeah, I agree with you. And also, who has the money to go after them? Yeah. I completely understand. But it's better than nothing. Yeah. Sorry.
Similar, because in advertising we pitch all the times, and sometimes we pitch different ideas that, for whatever reason, are not proceeding, either for money or for other purposes. So that's the way to go, or by having like the copyrights.
I would do both,
Presentation is fine.
I would do both. As part of your NDA, you can say that anything we show you belongs to us.
Okay, because sometimes you pitch ideas,
I know.
and then you see them happening
I know.
1 or 2 years when they have the budget or something.
And they do it themselves.
Yeah, they're doing themselves.
And it's your idea.
Exactly.
But that happens. that doesn't really happen as much as Cyprus.
That doesn't happen.
Sometimes we see it
in my experience working abroad for many years. I've only came across it. Actually, I didn't know it was a thing until I came back to Cyprus.
Exactly.
So, guys, I mean,
because
that's what I tell you. Don't do it.
No, you need to be very careful about how you define the confidential information. So this is what you were saying, because it's quite vague. You need to be very specific that this, and this is what I mean. And also, you need to be very specific with the purpose of the disclosure. So the information is being disclosed to you solely for the purposes of assessing whether or not you want to proceed with funding, for example. So that they can't go around and say, oh, but I didn't disclose it to a third party, so I'm not in breach of this NDA. No, you didn't adhere to the purpose. So you need to be careful with drafting, or the person who's going to be drafting your NDA. Yeah?
Can you maybe have a clause as well, like if you decide to proceed with this idea, like collaborate with me for future purposes? Is there a thing? Or?
Yeah, I mean, I'd be very careful with clauses like that. Yeah. I'd be very careful with them.
The other thing that you can do is just not let anybody have a copy of what you're presenting. I stop all my clients from ever passing the file across if they're presenting online or if they're presenting in any way, shape or form. I say, you present, and if anybody else wants to see it, you present again. You do not at any point pass over a copy of what you're presenting.
You mean the PowerPoint or PDF?
Well, the majority of times you just send a PDF version of the presentation after that to the client.
No, you don't. It's still our work. We are not giving it.
But what if they want to like examine the whole presentation?
Then they do it with you online.
I think culturally that can be quite but I think culturally that can be quite difficult in Cyprus because we ran into that a couple of times, and they were like, no, if you don't send it to us, we're just not going to work with you.
And then you go fine.
Yeah, no, of course, but I think it can be quite.
Ideas and there are all sorts of
Okay, this is the last slide. I'm really sorry. Okay, after you've got your IP rights, okay, whether or not they need to be registered, you need to ensure that you're proactive in terms of their protection. So for instance, with trademarks, it's always a good idea to pay a service that's going to monitor trademark applications in the jurisdictions in which you're interested and inform you if something similar has been registered, because not all IP offices will stop a similar mark from being registered. I have some clients who are like, wait, what? They're not going to stop it? And I was like, no, you need to be proactive, unfortunately. You need to file an objection. And there's also something called the customs application for action. You file it with customs, so the customs department. It's free of charge. You list your IP rights. And Cyprus customs in particular, apart from monitoring border imports, has the right to conduct what's called market searches, go into various shops and seize products that might be infringing. Yeah, I'm happy to answer questions.
Does that fall? I know a few people that wanted to protect their work by sending their work through email or through mail.
Yeah,
is that indeed applicable and valid?
Look, with copyright, this is usually for copyright, it's always a question of proving who came up with the idea, not with the idea, with the work first. Some people think email will help them.
By
post, double registered post. That's all, and you don't open it until there's a dispute. That.
Even the manuscript of their poems or of the book, they send it by post. And they can claim that it's mine because it's here. It has the post stamp on the date that I sent, and it's.
It's not official, but it is definitely used, and it can be useful as evidence. It can be useful as evidence. A lot of people, though, use what we now call digital repositories, so something called iDepot with the Benelux IP office, the World Intellectual Property Organization used to have one, where you upload a PDF of your work, you ask them to keep it secret, and in exchange you get a timestamped certificate saying that at this date, Joanna submitted this. So there is some sort of digital proof. I think some of them use blockchain as well, actually. So it's the modern way, anyway, of the double registered envelope. Yes. Sorry, am I allowed? Am I allowed to ask? Yeah, okay, Nene.
If you do decide to register something by copyright, you can do it.
You don't register copyright. I mean, not in Cyprus.
If you do decide to register a script, a film script.
Yeah.
I remember we go to the public library, register it.
That's not registration. That you deposit it. You deposit a copy. Registration needs to have an official sort of dimension to it, like the U.S. Copyright Office, where you can register it.
Something to the public library.
Yeah.
That's just to prove that.
Yeah, it's a question of providing evidence at a later stage in the event of a dispute. Yeah, and there's the public library, there's the ISBN, there's all of these.
Have to go to court for something.
Yeah, some people do an affidavit. I mean, no. Okay.
Thank you.
I believe that you can continue the conversation in the corridor.
Yeah.
We will have some wine.
Of course, if anyone has questions, please feel free.
I want to thank you very much. All three guest speakers, thank you very much for being here.